yet. Places seats. That's actually some sense. I can't my back in the car, so. Gentlemen, good morning. Good morning. Yeah, I got a couple of things. Yeah. Like the consideration for goodwill business. Yeah. Could you say part of that consideration is they got $270,000 discount for the popcorn you told the purchase agreement? You could say, will it hurt you?
It doesn't really. Here's my answer. Okay. They're saying, where's the income? Where's the income? They want us to stick to country. They want us to stick to their country. They don't want to stick to ours. To me, that's a huge contradiction. Jury, I don't think it will pass. We're supposed to treat their country. Our country is just nothing more than
What in their country?
it's nothing. Oh, he insults me right now. We're supposed to, the jury's supposed to take those and say, okay, these trump all other countries. We're supposed to strictly follow those, not follow these.
I'm gonna go grab a
Yeah.
drink. Do you want anything?
No,
You need anything?
I'm good. And
It's the law or they or point or something like that. They act like that.
Josh is gonna ask that. Just because you have, doesn't mean it's not translated, they're not too mutual. It's not just, it's something.
Don't we still contend that the, figures that we not working at?
Yeah. Oh, yeah. Oh, yeah. Absolutely. Part of what I want to do is what I always about. You heard Tom say all that for a while. Listen, yeah. All the evidence. He got up there yesterday and started to ask the question. We're supposed to have all the evidence.
And one other question I just thought of last night, even though it was not speaking, is Mickey owed third federal abatement the money he borrowed to buy the business. They didn't find out about it till it was too late to find that he died.
You're when they didn't file anything?
They did because it was too late. But they called.
Yeah.
But so he did owe other people.
Yeah, I don't know if I can get into that for you. Let me take a chew on that.
Okay.
If we had like another claim that was filed, that we filed a lawsuit against a public record, we could do something like that.
And I think PNC Bank gave us a couple thousand
I'm
dollars.
sure.
They didn't get paid.
Well, when Mickey told them, Josh, grandson, then they had to contact the bank when
I was gonna look at the sales agreement to see if it even mentioned that PNC Bank.
Research children that says, never, one of the things you're going to do is push this off on job markets.
Yeah, I really
Yeah, the point is, you never had any contact.
Nope.
You have no side agreement. He said you can't, some places, you can't assign it. That's what I was getting. Okay, but again, he was trying to argue, and I'm fine. I'm gonna tell the truth. What I'm trying to say, always our open statements. We're here to see the truth.
Morning, Your Honor.
Morning, Your Honor.
Morning, guys. Morning.
No part of my. So, yeah. So, redo your regress. All right. And then Marty.
Well, it wasn't much traffic this morning. It wasn't so
No,
bad.
no, it was.
Quicker today than yesterday.
Yeah, that was. I
Where
like
do you come from?
Cleveland. I don't like driving 80 miles an hour in the morning all the way though. It's just.
It's unique. I find that coming down Route 8, it's right when you hit about Stowe, it seems like it turns into a drag strip. Everyone's just flying through those curves of Cuyahoga Falls at 80 miles an hour, or you have someone going 60. No happy.
The,
Also speak pretty tough, speaking down.
Oh, yeah. Oh, yeah.
I hear on the radio all the time when I'm coming down here that Route 8 is sort of a accident waiting to happen. It's just, there's always accidents.
Yeah, they had. I was actually taking my son to a basketball game over in Macedonia, and I had to drive right past Route 8. It looked good. And I saw the video. Definitely looked.
It's not the first truck to go over the side like that either.
Really?
That's happened before.
Oh, yeah.
It's a tight turn and some of the drivers take it too fast. Especially if the road's wet or something. But I've seen several accidents like that. A couple where the trucks have gone over on their side, some of them. That's the first one I've ever seen that went over the complete side of the road and then exploded, but.
Yeah.
Is that the one where that bridge was on fire?
Yeah.
Yeah.
Oh, really?
Well, what was it, about a year ago, then a fuel truck,
Yeah, that's
flipped
right.
over and they burned down a lot of trees along the side.
Yeah, that was in the same area, but it didn't go over the side of the bridge.
Right.
But yeah, you're right. I remember that.
Cleveland, we have a main road called Dead Man's Curve.
Oh, yeah, I know where
Oh,
that is.
yeah.
There's a lake. It's, I see a few trucks, they don't believe it or something.
I found it interesting, at least from what I looked, I couldn't see any part of like the side of the bridge. We went up and over that concrete without a problem. Everything else stayed intact.
They down.
Schedule for today. I anticipate Rick will get back up there for some redirecting to be crossed. And then Mark will be next.
Okay.
Scott.
Okay.
We don't even have to do the PNC. Then we'll go into Sarah.
Okay.
And then Jack.
Okay.
So.
Might be a full day.
Yeah, I would say, well, regardless, I always like to take a break before closing, so even if we get through all the witnesses today and come back and do closing, it's helpful to digest everything.
Okay.
So you can do closing, charge the jury, and then they can go right into the.
Okay.
But if not, we can save Jack for,
Yeah, okay.
it depends on what, sorry, depends on what witnesses you guys.
Right. Yeah, I'm thinking if you get through your case, maybe we break and so there's at least some flow tomorrow
Yeah.
to start ours. Because
Yeah, no, that works.
I think I'll be done in half a day.
Okay. Not a rock star.
No, not a rock star, not yet.
Too early for rock.
See if I can do this again. To use document camera.
Thanks, Adam. It's not typical. Just tell us when you're set up and we'll start then. No worries. Morning, how are you?
Upstairs. Oh, okay. Yeah. Yeah. And the office is in.
It's open.
It is.
Christy, you ready? Okay, no worries.
Well, no, no.
This is the list.
That's it. Wednesday, Tuesday. Right. Tuesday, Wednesday.
Brian, you feeling better?
You get shake the week.
Yeah, it takes a while. And Felicia, you were never sick, or you're feeling better, right? You were sick a little bit.
Yeah, but I think mine was just stress and just a regular cold.
Yeah.
Better. I remember that first day I felt better than the second day.
Ready? Okay, wonderful. We will go on the record. It is Tuesday, January 30th, 2024. It's 9:08 a.m. State of Ohio versus Erica Stefanko, case number CR 2012-07-1887-B. Defendant is present, and we are going to review the jury instructions this morning. Have both sides had the opportunity to review those?
Yes, Your Honor.
Yes, Your Honor. Okay. And do we have any changes or anything that the parties disagree with that we need to discuss? Yes, from the defense. What about from, we'll start with the state.
Under consciousness of guilt.
Can you give me a page number?
Sure, page 9.
Okay. Thank you. That's much easier to find. Okay.
The state would like testimony has been admitted indicating the defendant hid from the authorities and/or attempted to conceal a crime. And you can go into it by placing Ashley Bigg's car in a cornfield and/or going back to the scene to clean up. Or you can just stop with indicating that the defendant hid from the authorities and/or attempted to conceal a crime. I've requested that and gotten that in consciousness of guilt.
So you're,
Oh, sorry. That's fine. I have requested that in consciousness of guilt instructions, and I've gotten that, Your Honor.
so you're requesting that after the first sentence, which says testimony has been admitted indicating that the defendant hid from the authorities and/or attempted to conceal a crime?
Yes. I think testimony came out from the defendant herself and Chad and Mary Brinkman that those things occurred, meaning attempted to hide or conceal a crime.
Okay, I'll hear from the defense.
Thank you, Your Honor. We are objecting to the inclusion of consciousness of guilt in its entirety.
Based on what?
That would primarily be based on case law and lack lack of facts that support the instruction. And the evidence of flight is admissible as it tends to show the consciousness of guilt, and the instruction is appropriate if there's sufficient evidence in the record to support it. What case law in this jurisdiction and around the state of Ohio indicate is that the record has to contain evidence from which reasonable minds might reach the conclusion sought for the instruction. In this, basically, that the defendant's conduct in leaving the scene of a crime does not warrant the flight instruction. And in this particular instance, that's really the only evidence that we have, is that she left the crime scene or alleged crime scene. But I can give the court a number of cases and have in fact prepared a little memo of law for the court and for the state to review on whether or not it's appropriate. But departing the scene is insufficient, and departing the scene in a circumstance in which the suspect is going to a place in which they would normally be found is not considered to be enough.
They would normally be found behind a barn with their 4 kids in the car.
In a vehicle that is owned by the family, that is parked on the property that that vehicle is registered to, a quarter of a mile away from the alleged crime scene, absolutely. The case law is what? Correct. And she was driven there by the co-defendant. As the facts came out in the case, we wouldn't dispute that this would be an appropriate instruction for Chad, because he's the one that drove the vehicle. He's also the one that was hiding in the woods. But in addition to the fact that she was located in a place where authorities would reasonably expect her to be because of the ownership of the vehicle and the relationship to the property owners, when the police approached her, she made no attempt to run. She made no attempt to hide. She did nothing. She simply sat in the car and waited for them to come up and was cooperative with them the rest of the time. There has to be some indication that the defendant actually made an attempt to elude capture or to flee from the police. And it's our position that there's insufficient evidence. Like I said, if I can approach, I can give the court a little summary of law that I put together. And there is one case that is unreported that is almost directly on point, where they found that it was an insufficient amount of facts to support the instruction. You know, unfortunately, this is a circumstance where most of the case law that you're going to find is going to be addressing whether or not it was at error, in that whether or not it was objected to. If it's not objected to and it's plain error, they're just ultimately dismissing it. So it's a little bit more complicated to find one where the court will go so far as to say, this never should have been given. They're usually addressing whether or not it had an effect on the outcome at the appellate level. So the cases that I cited to, in that one in particular that's unreported from the 11th, they actually are looking at this never should have been introduced in the first place. And we feel that the facts and circumstances of this case are substantially similar to those, in that submitting that to the court, to the jury for consideration, would be error in this particular case.
In your honor, I believe the state filed a motion from before, and as I stated, please incorporate all the state's prior motions into this case. We're not arguing flight, we're arguing consciousness of guilt. And the state argues that we put forth sufficient evidence to sustain a consciousness of guilt jury instruction from the fact that they were hiding. Testimony came out, is there any reason for them to be behind that barn? Chad testified they parked initially behind the house, and when they saw a cruiser go by, they went back even further behind a detached garage to elude or evade apprehension, Your Honor. It was testified, well, the defense just stated, a car that is registered there, that may be Chad's car that's registered there. They do not live there. You do not expect to find a family of 4 hiding behind a detached garage with a baby that needs nursed every so often, that's months old, in the middle of the night between 3 and 4 o'clock in the morning. So yes, the state believes that we've put enough evidence forward to show that they tried to conceal a crime. Another thing, not just that part is hid from authorities, and then, or attempted to conceal a crime, they drove, which the defendant admitted on the stand, she followed Chad to that cornfield, and we're arguing complicity. He drove that car so far in that cornfield, you cannot drive it anymore unless you're going to get into the water. You could not drive it. And the defendant testified herself that had the field been planted, where evidence will come out and show through that tape, it would not have been found had the corn been high enough. So yes, the state believes we put forth sufficient evidence to sustain a consciousness of guilt jury instruction that the defendant hid from the authorities based on her testimony, Chad's testimony, and where they were found, and the officer, and that was Officer Hargett's testimony, and or attempted to conceal a crime. And that's based on Mary Brinkman's testimony from the statements of the defendant's statements, the testimony, and Chad's testimony.
Your Honor, I would just like to point out that at least as it relates to the vehicle, the state's correct. She said Chad drove the vehicle to his grandma's house. Chad parked that vehicle where it was supposed to be. Chad ran and hid in the woods. There wasn't even any evidence offered that if our client had the opportunity that she could have left that residence. And the reality of the situation is they were found immediately. That's where the car belongs. That's his grandma's house. They're known to be there. They're within the vicinity. That's not hiding. As it relates to the cornfield, I believe that her testimony was not that she followed him to the cornfield and watched him pull back. Her testimony was such that he told her to pick him up at the cornfield, and that she parked on the bridge and waited, and he emerged from the cornfield. There's a big difference. She didn't participate, and there is no physical evidence to indicate that she knows what part of that cornfield that car was in, or what he did once he drove in there, or that she even saw him drive into the cornfield.
Okay. As for the hiding part, Your Honor, Erica, the defendant, testified that she was behind there for an hour. What is the purpose of being behind there at 3-something in the morning for an hour? And it's a theory of complicity.
So I'm going to reserve judgment until I hear all of them, and then we'll take a break.
Okay.
So what's the next one?
Do you have anything else?
I didn't find,
Okay.
besides that, the state did not find any errors or corrections needed in the jury instructions.
We also need to add the exhibit numbers. Thanks, Adam.
We do. And Your Honor, I have a couple other small
Okay.
grammatical more issues. Page 2, under the definition of evidence, and I guess reasonable minds could disagree on this, but to me, the way that this is worded, the punctuation in it makes it sound more like
Which line
Where
are we
are
looking
you?
at?
evidence is all the testimony received from witnesses, the exhibits admitted into evidence, and any facts agreed to by counsel which the court instructs you are true. To me, it seems like there should be a period there, and then another sentence that says facts agreed to by counsel or stipulations, and stipulations will be later defined. Just to make it clear that facts accepted as true is only referencing stipulations as opposed to exhibits and witnesses.
Any objection from the state to that change?
I didn't follow, Your Honor.
I didn't follow that.
So she says evidence is all the testimony received from the witnesses, comma, the exhibits admitted into evidence, or I guess no comma, and the exhibits admitted to evidence, period. And
No, I
then-
want the period after facts agreed by counsel.
So you want to keep the commas and put the
Mhm.
period after that, and then add a sentence saying,
Facts agreed by counsel are stipulations, and stipulations will be defined for you later.
So you don't disagree with anything, you just want to add the language that.
I just feel like it's worded weird, Brian, really. It's just a grammatical thing for me. To me, the way that it's written,
just the OJI.
I understand
So
that, but
that's-
legalese is not always that clear either, Your Honor.
Is that, does the state have any issue with us making that change?
I think we should just go with OJI, so we would object to changing. You
Okay.
do define stipulations later on or whatever, right?
She does.
Yeah, on page, I think. Let's see what page they're on. Stipulations are defined on the next page. Okay, so I'll consider that. Okay,
Oh, there was one other thing. I'm sorry, Your Honor.
okay.
Under stipulations, the admissibility of audio recordings. The recorded conversation, we've been talking about it as the recorded conversation. I don't know what audio recordings, we haven't really referred to it as audio recordings.
So what do you want it to say?
The recorded conversation.
The admissibility of the recorded conversation?
We don't have an objection to that, Your Honor.
Okay, so we will change where it says the admissibility of the audio recordings to read the admissibility of the recorded conversation. Is that your change, Attorney Easter?
Yes, Your Honor.
Okay, and no objection from the defense, so that
Nope.
change will be made.
Back to page 2, last two sentences. It says, another example of an inference is the old saying, where there's smoke, there's fire. From the direct evidence of seeing smoke, you can infer that a fire exists. We're going to ask to strike that. There's already one example given, and I think that that example that's given as it relates to rain and wet ground is sufficient for the jury to understand what the idea is. Honestly, I feel like the one with the smoke, there's fire is just prejudicial to a defendant in any instance, because I can't tell you how many times I've heard a prosecutor argue that in their closing sentence. It gives an indication that basically any shred of evidence means that there's enough for something there. And I think the rain one is very, very clear. So we're just asking to strike second example.
Okay, I'll hear from the state.
Your Honor, is that from OJI?
Yes.
Oh, I would,
We'll look at it though, because I agree, there's one example given. I don't know that the second is necessary. So I'm actually going to strike that. We already have the one example, so that will be struck.
And there were a couple typos, but I already told Tristan that. The only other thing that I can think of, Tristan, you have a typo on page 12 too. I think it's supposed to say any more importance. I'm not sure. The first sentence, it says, nor does that person's vote have any more important than others.
That's the top. It's the first line on page 12. Importance. Okay.
Other than that, we have no further objections, Your Honor.
Okay, so the state wanted recorded conversation. That change will be made. Defense wanted bottom of page 2. That will be made. And then there's still 2 outstanding issues, which is the consciousness of guilt instruction. And then the defense is also asking for under evidence for that sentence to be changed. So I'm going to look at both of those and then I'll let you know how I rule on them. Let's talk about the evidence of what exhibits are not going back. And do we have gloves? There was a box of gloves. You have the gloves.
She does.
Perfect. Okay. Chrissy has the gloves.
do you want, the state was to bring you Michelle Snyder's the clean report for Michelle Snyder. We have that. It just needs to be more joint exhibit. I believe it was 3.
Okay. I'll give that to Christy, please.
Did you want? And we were to put on the record, Your Honor, our stipulation for the cause and manner of death determined by Dr. Amy Joliffe of Wayne County.
Which exhibit was that? I guess that's a
It wasn't an
stipulation.
exhibit, it was a stipulation,
Okay.
Judge.
That's fine.
And the stipulation, and it's based on Wayne County, Ohio Coroner's Comprehensive Report of Death Investigation dated June 21st, 2012. And that's by Dr. Amy Joliffe. And under primary cause, it's strangulation, manner of death, homicide, blunt force trauma to the head and extremities.
So you want that line changed to say, do you see on page 3 where it says stipulations? We have cause and manner of death of Ashley Biggs by strangulation and homicide opined by Dr. Amy Joliffe.
Yes.
And we'll take
And,
it.
and no, I'm sorry, the part by the blunt force trauma, that's a different section. It should be primary cause, strangulation, manner of death, homicide.
Cause and death. Okay, so are you looking at page 3?
No, page 1.
Your Honor, I think you're looking at Dr. Kohler's report. It's not on there. It's from,
No, I'm looking at the stipulations on the jury instructions. And I'm trying to figure out what language you all want changed. Are you asking for
Oh.
something to be changed?
I didn't know the stipulation was, oh, hold on. Yes, page 3 of the jury instructions.
You know, I think if it simplifies it,
Oh, I must have skipped over that. I didn't see that was already in there. Cause and manner of death. It should actually, well, just to be completely accurate, the cause of death is strangulation, the manner of death is homicide. This groups them together. Cause and manner of death are by strangulation and homicide.
What would you like it to say?
The cause of Ashley Biggs' death is strangulation. The manner of her death was homicide, opined by Dr. Amy Joliffe. No objection.
Okay, we'll make that change.
And there will be no exhibit number because we're just doing this written
Right.
stipulation. So that can be crossed out.
Okay. Any other?
No, Your Honor.
Anything for the defense?
I don't believe so, Your Honor.
Okay, so we will take a recess so I can go review the brief and then we'll come back and
oh yeah,
make that decision. Great, thanks, everyone.
Kristen spelled Ariel wrong.
Which page is Ariel spelled? Okay, Tristan's making the agreed changes, and I just wanted to rule on the other two changes that we discussed. The first one being the stipulation language on page 2, that is the language straight from the OJI, so we're going to leave it as is. And then the other issue that the defense raised was the consciousness of guilt. And in your brief, in quoting the Johnson case, they said it must be clear that the defendant took affirmative steps to avoid detection and apprehension beyond simply not remaining at the scene of the crime. And this is a discretionary instruction. However, in State v. Williams, it said it's universally conceded that the fact of an accused flight, escape from custody, resistance to arrest, concealment, assumption of a false name, and related conduct are admissible as evidence of consciousness of guilt and thus guilt itself. So the ruling is that that instruction is going to stay. So Tristan is making the changes. We will get clean copies to everyone to review. Did you have something?
I just wanted to know what version, is it going to be the extra line the state asked or what's in there now? That was part of what the court.
We're just using the one that's in the OGI, so I'm not adding an extra line. So we're keeping the OJI. Are those, I think Adam might have the clean copies.
I'm sorry, Judge. For clarity, I'm not sure. The language in OJ, could you just read that section as you're going to read? Just
Sure, it's the consciousness of guilt section. Testimony has been admitted indicating that the defendant hid from authorities. You are instructed that this conduct alone does not raise a presumption of guilt, but it may tend to indicate the defendant's consciousness of guilt. If you find the facts do not support the defendant's conduct, or if you find that some other motive prompted the defendant's conduct, or if you are unable to decide what the defendant's motive was, then you should not consider this evidence for any purpose. However, if you find that the facts support the defendant engaged in such conduct, and if you decide that the defendant was motivated by a consciousness of guilt, you may, but are not required to consider that evidence in deciding whether the defendant is guilty of the crimes charged. You alone will determine what weight, if any, to give to this evidence.
And I thought the OJI had a space where you're supposed to include the conduct.
Do you have it? Do you have that section?
I mean, I don't have the OJI here in front of me, but
Okay, I'll
my
have Tristan
understanding
look
is
at it.
it actually says to include the conduct, which is
And
what we were
You want the conduct to be or attempted to conceal a crime?
correct.
Okay, we'll look at that. Okay, we'll look at that and come back. The jury's starting to arrive. So once we get these done, we'll get started.
Judge, and you were still planning on reading instructions, most of the instructions prior.
Correct. Yes, that's the plan. Thank you.
Off the record.
Oh, what, so we're off the record?
Yes, this is just procedural. I just want to make sure my PowerPoint plays. Can you leave it so I can put it up? You have to do something with yours so I can test mine.
Do you want to test it right now?
Yes.
Okay, you're welcome. Just, but then all the microphones, just so you know, are on.
Have you seen that PowerPoint?
No, it's my closing.
Okay.
Okay.
I've never given my closing. I've given my opening. I've never given a closing.
Or something. Right. Something to eat. And that, so yeah, he wasn't. Come forward and raise the.
Okay. Just me. Just. With the You get to know that.
I know. Don't worry.
You go inside. Go on. Try to speak up.
I just want to make sure that they're.
Oh, that's. Okay. Check the one.
Hey, also.
Yep.
We had talked about the accounts. Years. So, judge.
I'm glad you brought that up, I thought of last night, and I forgot.
We had talked about it at the
I
beginning.
know.
We had originally talked about renumbering, but I can't do counts. I mean, I don't care how you guys want to do it, but I think if you don't do 1 and 2, renumber them, we need to at least tell her, you know, which counts 14 is what.
I think we would find, you know, order.
Yeah.
So then, nothing less.
It's fine.
Which nothing else we have. I mean, you'll get it.
Yeah.
So what I'll do, I'm gonna do since I'm breaking you guys off, and I'll just change. Just with the two.
And on the burden too. Yep.
Yeah. Say, hey, yeah, I'll let Judge go on the record. Put something on the record.
Okay, let me see, you gotta put it on the record.
Yes.
As we know, but, okay.
Correct.
Yeah.
Just so there's no issues, I just. bring you guys off.
Perfect.
I would just double check this. Yeah. Those are all set, still, we get from there, and then we'll go back on the record real quick. Yeah.
I just, like, one of the things where it's like, God, I just realized that's what you do.
Delayed reaction.
But that's all right, I mean, she's got somebody with. Let me know, but still.
You can ignore it even. Somebody else about it. Oh. Oh. I wrote it down. Why will you know? No way, no states vote for the West. Sorry. Right there. Dear Christine, can you check the date? It's wrong, no fiction. Thank you.
Okay, we're going to go back on the record. It is 10:01 a.m. State of Ohio versus Erica Stefanko. Just a couple things to clean up on the jury instructions. The jury has all reported, so they're ready to go. First of all, regarding the consciousness of guilt on page 9, I am adding and or attempted to conceal a crime to that language. Then it's my understanding that the parties would like to revise the counts. So on page 5, it refers to count 15. Count 15 will now become count 1. Do both sides agree to that?
We do, Your Honor.
Yes, Your Honor.
Okay, and then on page 7, what was originally count 17 murder will now become count 2.
No objection to that, Judge.
Same here.
Okay, are there any other changes before Tristan prints off the final copies?
Just also on the verdict.
On the verdict forms. That's a great point. Okay, so we will change, again, count 15 aggravated murder to count 1. And we'll change count 17 murder to count 2.
And Your Honor, under the BCI stipulations in the jury instructions, page 4, joint exhibit number 3's date should be October 4th of 2012. I just verified that with the exhibit.
Okay, hold on. You're looking at the new?
Yes,
Let me switch to that. Could you tell me the page? Did you say page 4?
page 4.
Page 4. One more time?
The last one, the authenticity of the resort from Michelle Snyder, joint exhibit 3.
Mhm.
The date should be October 4th of 2012, not 14.
Okay, let's see what Tristan's saying. Okay, Tristan's going to change that, and he'll also change the verdict forms. Anything else?
No, Your Honor.
I don't think so, Judge.
Okay,
Thanks.
once we have all of the forms correct, we will bring in the jury. I'm going to read the instructions up to through page 10. And then the state may start with their closing argument. Were you able to get the technology to work?
Now, it works now, but Einstein's law, it won't work like
It'll work. I have confidence. That's right. I have my magic magistrate. I highly recommend always hiring someone in their 30s. Their knowledge. Okay. Anything else from either side?
No, Your Honor.
No, Your Honor, thank you.
Okay, we're going to take a brief, I guess it'll be about a 5-minute recess to get all of these printed. Once they're printed and ready, I'll have the jury brought in, okay? Okay, we'll go off record, take 5 minutes. Okay, Chrissy, we're gonna go back on the record. It is 10:17, State of Ohio versus Erica Stefanko. Did both sides get a clean copy of the jury instructions?
I believe we did, Judge.
Did you get one?
Judge, I think that Tristan came out and he said there was one additional change. I think he found the count numbers within the body of it. He said he was going to
correct.
change it, but we don't have that. But other than that, we have essentially everything is
Everything.
correct.
Okay.
Good enough to go forward. We can get a clean copy later.
Yeah, I think it was under complicity. We changed aggravated murder to count 1 and murder count 2.
But other than that, I think everything else is-
Okay, we're ready to bring the jury in?
Yes.
Okay, thank you, Adam.
All right. Suffolk County Court of Common Pleas is now in session. The Honorable Jennifer D. Tal presiding.
Good morning. Thank you. You may be seated. Good morning to our jurors. Thank you again for all being on time every day. We appreciate your service so much. What's going to happen at this point is I'm going to be giving you your jury instructions. So at this time, my bailiff, Adam's going to be handing out a copy for each of you to follow along. When I'm finished reading these, I'll just ask you to turn it over and the parties are going to begin their closing arguments. Thank you, Adam.
Oh, keep going. Yeah.
Does it also have the verdict forms? Yeah. Everyone has one? Wonderful. Thank you, Adam. Okay, good morning, ladies and gentlemen of the jury. You have heard all of the evidence and the arguments of counsel, and it is now my duty to instruct you as to the law in this case. The court and the jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law or to apply your own idea as to what you think the law should be. A criminal case begins with the filing of an indictment, a statement which informs the defendant that she has been charged with a particular crime. This indictment may not be considered by you for any purpose. The plea of not guilty is a denial by the defendant of the charge and puts in issue all the essential elements of the crime alleged. Burden of proof. The defendant, Erica Stefanko, is presumed innocent until her guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense charged in the indictment. Reasonable doubt. Reasonable doubt is present when you, after you've carefully considered and compared all the evidence, cannot say you are firmly convinced of the truth of the charge. It is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof of reasonable doubt is proof of such character that an ordinary person would be willing to rely on and act upon it in the most important of their own affairs. Evidence. Evidence is all the testimony received from the witnesses, the exhibits admitted into evidence, and any facts agreed to by counsel which the court instructs you to accept as true. Evidence may be direct or circumstantial or a combination of the two. Direct evidence is the testimony given by the witness who has seen or heard or felt certain acts or facts to which he or she testified. It includes the exhibits which have been admitted during the course of the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. Circumstantial evidence uses common experience about information obtained from direct evidence to infer or imply some other fact or conclusion reasonably. To infer or to make an inference is to reach a reasonable conclusion of fact, which you may, but are not required to make from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. For example, if a witness testifies that he looked out a window and saw that the ground was wet, you may reasonably infer that it had rained, or you may conclude from other evidence that something else caused the ground to be wet. An inference based solely and entirely upon another inference, unsupported by any additional fact or by another inference from other facts, may not be relied upon by you. A second inference may be drawn upon a previous inference if the second inference is based at least in part on additional facts. And remember that direct evidence and circumstantial evidence are of equal weight or probative value. Exhibits. A number of exhibits and the testimony related to them have been introduced. The numbers on the exhibits serve the sole purpose of identification and should not be considered for any other purpose. Most of those exhibits admitted into evidence will be given to you at the time you begin your deliberations. There are other exhibits that, due to the nature of their condition, will not be sent back at the time you begin deliberations. However, those exhibits will be identified for you by list and made available to you upon your request under the control of a bailiff or other person designated by the court. Stipulations. A stipulation is an agreement by both sides that a certain fact is true or that a witness would testify as to certain facts or opinions. The state of Ohio and the defendant have agreed to the following stipulations. The authenticity of aerial photographs of the cornfields off of Poor Road, States Exhibits 26 through 31. The authenticity of the Walmart video and or still photographs, States Exhibit 95. The authenticity of the Verizon wireless phone records for phone number 330-388-3224, States Exhibit 102. Cause of Ashley Biggs' death was by strangulation, and the manner of death was homicide, as opined by Dr. Amy Joliffe. The authenticity of the drone aerial video of multiple locations, that's States Exhibit 1. The admissibility of the recorded conversation, States Exhibit 4. The camouflage pants being sized for a male and the size of the pants, States Exhibit 112. The authenticity and contents of the BCI forensic laboratory reports dated February 19, 2013, authored by Christopher T. Smith, Joint Exhibit 1. The authenticity and contents of the BCI forensic laboratory reports dated July 24, 2013, authored by Christine Hammett, Joint Exhibit 2. And finally, the authenticity and contents of the BCI forensic laboratory reports dated October 4, 2012, authored by Michelle Snyder, Joint Exhibit 3. Credibility. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You will apply the test of truthfulness, which you apply in your daily lives. These tests include the appearance of each witness upon the stand, his or her manner of testifying, the reasonableness of the testimony, the opportunity he or she had to see, hear, and know the things concerning which he or she testified, his or her accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. Expert witnesses. Normally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. Questions have been asked in which expert witnesses were permitted to assume that certain facts were true and to give opinions based upon those assumptions. You must first decide whether the assumed facts on which any expert based his or her opinions are true. If any assumed fact was not established by the greater weight of the evidence, you will decide the effect of that failure on the value of the opinion of that expert. However, as with other witnesses, upon you alone rests the duty of deciding what weight to give the testimony of the experts. In deciding its weight, consider his or her skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and deciding the weight to give to the testimony. Defendant testifies. The testimony of a defendant is to be weighed by the same rules that apply to other witnesses. Multiple counts. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your finding as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any one or all of the offenses charged. Count 1, aggravated murder. In count 1, the defendant, Erica Stefanko, is charged with aggravated murder. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 20th day of June 2012 through the 21st day of June 2012 in the county of Summit and state of Ohio, the defendant did purposely and with prior calculation and design cause the death of Ashley Biggs. Purposely. Purpose is an essential element of the offense of aggravated murder. A person acts purposely when it is her specific intention to cause a certain result. It must be established in this case at the time in question, there was present in the mind of the defendant a specific intention to cause the death of Ashley Biggs. Purpose is a decision of the mind to do an act with a conscious intent to produce a specific result or engage in specific conduct. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to that person unless he or she expresses it to others or indicates it by his or her conduct. The purpose with which a person does an act or brings about a result is determined from the manner in which it is done, the means used, and all other facts and circumstances in evidence. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose or knowledge. Prior calculation and design. Prior calculation and design means that the purpose to cause the death was reached by a definite process of reasoning in advance of the homicide, which process of reasoning must have included a mental plan involving studied consideration of the method and the means with which to cause the death of another person. To constitute prior calculation, there must have been sufficient time and opportunity for the planning of an act of homicide, and the circumstances surrounding the homicide must show a scheme designed to carry out a calculated decision to cause the death. No definite period of time must elapse and no particular amount of consideration must be given, but acting on the spur of the moment or after momentary consideration of the purpose to cause the death is not sufficient. Cause. Cause is an essential element of the offense of aggravated murder. Cause is an act which directly produces the death of another and without which it would not have occurred. Conclusion, aggravated murder. If you find that the state proved beyond a reasonable doubt all the essential elements of the offense of aggravated murder, your verdict must be guilty. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of aggravated murder, then your verdict must be not guilty. Count 2, murder. In count 2, the defendant, Erica Stefanko is charged with murder. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about the 20th day of June 2012 through the 21st day of June 2012 in the County of Summit and State of Ohio, the defendant did purposely cause the death of Ashley Biggs. I have already defined purposely and cause for you. Conclusion, murder. If you find that the state proved beyond a reasonable doubt all the essential elements of the offense of murder, your verdict must be guilty. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of murder, then your verdict must be not guilty. Complicity. In considering each of the crimes charged in the indictment, the state of Ohio has presented a theory that the defendant, Erica Stefanko, acted in complicity with the principal offender, Chad Cobb, as an aider and abettor in the commission of aggravated murder, count 1, and murder, count 2. A person who is complicit with another in the commission of a criminal offense is regarded as guilty as if she personally performed every act constituting the offense. This is true even if she did not personally perform every act constituting the offense or was not physically present at the time the offense was committed. Aided or abetted. Aided or abetted means conspired, supported, assisted, encouraged, cooperated with, advised, or incited. Before you can find the defendant, Erica Stefanko, guilty of complicity by aiding and abetting, you must find beyond a reasonable doubt that the defendant supported, assisted, encouraged, cooperated with, advised, or incited the principal offender in the commission of the offense, and that the defendant shared the criminal intent of the principal offender. Such intent may be inferred from the circumstances surrounding the offense, including, but not limited to, presence, companionship, and conduct before and after the offense was committed. The mere presence of the defendant at the scene of the offense is not sufficient to prove in and of itself that the defendant was an aider and abettor. Testimony of accomplice. You have heard testimony from Chad Cobb, another person who pleaded guilty to the same crime charged in this case and is said to be an accomplice. An accomplice is one who assists or joins another in the commission of a crime. Whether Chad Cobb was an accomplice and the weight to give his testimony are matters for you to determine. Testimony of the person who you find to be an accomplice should be viewed with grave suspicion and weighed with great caution. It is for you as jurors, in the light of all the facts presented to you and from the witness stand, to evaluate such testimony and determine its quality and worth or its lack of quality and worth. Conclusion, complicity. If you find that the state proved beyond a reasonable doubt all the essential elements of the offense of complicity, your verdict must be guilty. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of complicity, then your verdict must be not guilty. Consciousness of guilt. Testimony has been admitted indicating that the defendant hid from the authorities and or attempted to conceal a crime. You are instructed that this conduct alone does not raise a presumption of guilt, but it may tend to indicate the defendant's consciousness of guilt. If you find the facts do not support the defendant's conduct, or if you find that some other motive prompted the defendant's conduct, or if you're unable to decide what the defendant's motive was, then you should not consider this evidence for any purpose. However, if you find that the facts support the defendant engaged in such conduct, and if you decide that the defendant was motivated by a consciousness of guilt, you may, but are not required to, consider that evidence in deciding whether the defendant is guilty of the crimes charged. You alone will determine what weight, if any, to give this evidence. Closing arguments. The court cannot embody all the law in any single part of these instructions. In considering one portion, you must consider it in light of and in harmony with all the instructions. The court has instructed you on all the law necessary for your deliberations. Whether certain instructions are applicable may depend on the conclusions you reach on the facts beyond a reasonable doubt. Counsel at this time will make their final arguments to you. The prosecuting attorney will begin, then counsel for defendant will follow. Finally, counsel for the prosecution will have an opportunity to reply. In making these arguments to you, the attorneys will be commenting upon the testimony that you have heard and the evidence that has been presented in this case. They will not intentionally try to mislead you. However, if their recollection of the evidence differs from what your recollection is, you must follow your own recollection. These final arguments are not to be construed by you as evidence in this case or instructions on the law. They are, however, intended to help you better understand the contentions of each side and the issues you are to decide. You should give both sides your close attention. If you could just place down those instructions, we will begin, and the state may begin their closing argument.
Ladies and gentlemen of the jury, in the beginning of this case, during opening arguments, the state said we are here to hold this defendant, Erica Stefanko, accountable and responsible for what she chose to do on June 20th to June 21st, 2012. That has not changed. Based on the evidence you've heard, this defendant is guilty and we need to hold her responsible and accountable. Now, whether you hold her accountable and responsible as the principal or the accomplice, all roads lead to the same place, that the defendant is guilty. The judge touched on in the instructions that she just read, and those are the instructions you're to follow, complicity. We said during jury selection and opening statements, please keep that concept in mind as you listen to the testimony and evidence. A couple points that I would like to point out is that, one, the defendant doesn't even have to be there at the scene. As long as she helps, encourages, assists, as long as they have a joint effort and they're working together. If one does one part and the other person does another part, they're equally held accountable. And in jury selection, my co-counsel gave an example of the mob boss in New York who calls in a hit for the person in California, or the getaway driver for the robbery in the car and the individual in the bank robbing it. Now, another thing with complicity is common sense and reason will dictate what evidence you have if someone is the principal or the person aiding and abetting. In the example of the mob boss in New York and the person who carries out the hit in California or the getaway driver, what DNA evidence do you expect from the mob boss in California? None. What DNA evidence do you expect from the getaway driver in the bank? None. And the state stipulated to those reports, okay? And we stipulated during trial, the defendant's DNA is not at that scene. It is not, because that's not the part she played as the accomplice. She did her part and he did his part. Now, what is she an accomplice? She's an accomplice to aggravated murder and murder. And one thing the court said and what she read is the purpose. Aggravated murder is to purposely, with prior calculation and design, cause the death of Ashley Biggs. One thing I want you, as you listen to how the state proved the defendant is guilty beyond a reasonable doubt for aggravated murder, purpose is specific intent. And you can't look into the mind of the defendant at that time, but you can infer her specific intent from the facts and circumstances surrounding what happened. The facts and circumstances such as how she ordered the call to lure Ashley Biggs to the scene, the fake name, the burner phone, where she called to lure her to a closed business, go to the back door, things of that nature. And facts and circumstances such as how Ashley Biggs was murdered, a zip tie, strangulation, but not the strangulation that most individuals are accustomed to, where it's the oxygen flow. Remember, Dr. Kohler testified that zip tie was placed so tight. It wasn't the oxygen flow, it was the muscles on the side of her neck, in her neck, that got squeezed so hard, it was the blood flow to and from her brain that caused the strangulation. So again, purpose is specific intent, and you can infer that specific intent since you can't look into the mind of the defendant from the facts and circumstances surrounding the crime. Prior calculation and design is they had a plan. They had a plan. That plan could have been thought up at the scene or ahead of time. And we're going to get into the defendant's statement and the recorded conversation. They had a plan, and it was thought of ahead of time. Murder, only thing missing is the prior calculation and design. It's the same thing. At a minimum, we all know they had a purpose based on the facts and circumstances of that case, of this case, to kill and murder Ashley Biggs once they got to that scene. Once they got there and Ashley showed up, from the facts and circumstances, you can infer at a minimum they had the specific intention to kill Ashley Biggs. Now, Chad murdered Ashley. The defense stated multiple times, tried to preface their questions with it. Chad killed Ashley. Chad murdered. He absolutely did. Detective Hitching sat in that witness stand and testified the date it happened. He believed Chad did the actual physical murder of Ashley Biggs, and he believed the same thing sitting in that witness stand as he testified that Chad murdered Ashley. The state believes the same. That's why when Chad testified, he stated every time he does an appeal, it's met by opposition by the state. We absolutely believe Chad murdered Ashley. We absolutely believed he put that zip tie around her neck, tased her, beat her, put her in that car. But you know what? He didn't do it alone. That is why we're here. The defendant played her part as well. She played her part. And it was her part that she played was in the murder of Ashley Biggs, make no doubt about that. The part she played in planning, the part she helped carry out from the beginning, the execution and the cover-up, it was the murder of Ashley Biggs, not a drug planting plan that you heard yesterday, not a meth or drug planting plan. We're going to talk about that. Now, the defendant is guilty. Chad is guilty. The evidence and testimony showed, and we've proved beyond a reasonable doubt, and that just means you're firmly convinced of the truth of the charges. In the ways we've proved it, and I'm leaving out her testimony because we're going to talk about that in detail. The ways we have proved, the state has proved the defendant is guilty beyond a reasonable doubt, that she planned this together with Chad, that they shared a common purpose or the same purpose, that she drove Chad to the crime scene, made the call to Domino's that lured Ashley to her death. These are the things that the defendant was part and parcel of. Followed Chad to the cornfield, waited on Chad to dump Ashley's body in that cornfield, drove Chad home to shower away the evidence, wash away anything tying him to that scene, went back to the crime scene with Chad to clean up, and you'll have that crate with the evidence, industrial grade cleaners and the brush, and hid behind the detached garage until they were apprehended by the police. How do we know this? Aside from the defendant's testimony yesterday, we know that, one, from Cindy Cobb, she testified, and there's a secretly recorded conversation that the defendant is making statements on. Okay? And we're going to get into that a lot too. There's Mary Brinkman who testified. Her testimony was that at that dinner at her house, the defendant alluded to making the phone call. She didn't admit to it, but she knew who did it. She didn't want to get them involved or bring them into the situation. She admitted she dropped Chad off at the business with Mary Brinkman. And she said that had the corn been planted up and grown, that Ashley and the car would not have been found. She admitted that she hid out behind that detached garage and that she had defecated on Ashley's grave. Grace got on the stand and admitted that she heard the defendant make that conversation, make that call to the pizza place and use a fake name. Chad got on the stand and he laid it all out. Chad got on the stand and he laid it all out. And that jury instruction, view what he says with grave suspicion. Absolutely, that's what Detective Hitchens said he did. That's why he didn't rush to judgment when he spoke to Chad or when Chad sent that letter. That's why he continued to do his due diligence and investigate the case. Chad said in that conversation, which was corroborated by the defendant in her testimony, they were together. They scoped out Ashley's car at work at Domino's. They were at the scene. They went to the cornfield. They went back to clean the scene, and they were hiding behind the building. Now, during the testimony, the defendant or the defense attorney tried to make out each one, Mary Brakeman, Cindy, Grace. They're all biased. This is the Cobb team trying to get the defendant out, the Cobb legal team. Somehow they're all biased, so what they say, you can't really put any weight to it. Remember the questions on cross-examination that were asked in the direction the defense attorney went? Yet his client confirmed every single thing that each witness on that stand said. Now, let's talk about Chad's testimony. Chad, throughout his testimony, he just wanted to go to Disney World. It's like two children, if you have children, coming up and they did something and they're coming up to their parent, and they're telling on each other. No, he did it. No, she did it. No, sister did it. No, brother did it. And you know what they do? The same thing Chad did on the stand. They tell, but they minimize their part. And that's exactly what Chad did. He minimized his part. He told on Erica and what she did. He minimized his part. When the defendant testified, what did she do? She sat up straight in that chair, minimized her part, denied her part, but blamed it on Chad. It's just cross. It's just, he said, just going back and forth. But the point is, they were together. They did it together. And it's your job, and your job only, to believe some, all, or none of what they said. It was only 3 people at that scene that night. The defendant, Chad, and Ashley Biggs. You've heard from Chad, and you've heard from the defendant. Ashley can't speak for herself. The evidence have to speak for Ashley. Let the evidence speak for Ashley. Now let's get into the meat and potatoes of what you're going to do and what you're going to focus on when you get back to deliberate. We can't get around it. One of the main pieces of evidence, the main piece of evidence, is the recorded conversation. And when you go back into the jury room, I would ask that you all take the time to listen. It is long. It is long, and I apologize about that. But please, this is a very important case. Please do not take anything in this case for granted. Look over everything. What evidence was presented to you? The defendant requested this meeting. Wasn't like Cindy lured her there. Wasn't like Cindy, hey, come to this meeting so I can set this up. The defendant requested that meeting. Both parties testified to that. Listen, don't just hear it. Listen to the conversation, the conversational tone. Listen to what was said and how it was said. There's no interrogation going on there. There's no arguing. It's matter of fact. The defendant is matter of fact in what she's saying, just like she was matter of fact in what she was saying on the stand. She wasn't intoxicated. Her own husband, who's been around her since the beginning of her and Chad got together, and ever since then, stated she's a typical drunk. She slurs her speech and she sways back and forth. I actually moved when he said it. She sways back and forth. She's a typical drunk. Listen to that call. Again, don't take anything for granted. Dissect everything about that call. That call took place in what the defendant believed was a safe place with a safe person. The defendant and Cindy Cobb testified that she told Cindy previously that she made that phone call. That's what Cindy testified to. That's what's on the recording. And the defendant testified that I told Cindy the plan beforehand. You never heard any testimony that Cindy told anybody about that call or about any plan. So the defendant believes she's talking to a safe person. I've told her damning information, and she didn't do anything with it. So this is a safe person I can talk about this stuff with. And in addition, she's in a safe place. They're in a detached, or no, it's a barn there. They're in a barn that's fixed up. They're in a barn, but it's only them two. This is an enclosed area. This isn't the area where I'm trying to whisper and talk to Detective Hitchings and you all are around. No, they're by themselves. So at this time, the defendant is free to have a free-flowing conversation with a safe person in a safe place. Hear her voice. Hear the tone of her voice. If I move away from this microphone, you can tell I'm moving away from the recording device. Listen to her voice on the recording and how it stays consistent. They're right there. Cindy said they were sitting down the whole time. There were no other rooms they went into. You're not missing anything. When you listen to the tape, see if there's any stops or anything in the tape. Please be thorough when you're listening to that tape. This is an important case to the state and the defense. The content of the recording, the subject matter of the recording. I can tell you what subject matter that you didn't hear, something you didn't hear mentioned, and that is anything about any drugs or drug plan. Listen to how serious she is about some of the things that she says in the conversation. You know, I told him if this is too risky, don't go ahead with it. I thought he could do it because I've seen him get away with some crazy shit. Listen to how she describes the plan they're talking about and think to yourself, is this a plan about planning meth or a plan about murder? How serious she's talking about it. Let's talk about the defendant's testimony. There were admissions on the stand, and she's noble. And yes, I didn't feel that way back then, but now I do. You know, now I'm a changed person, and now I'm different. Well, first of all, you're not to take sympathy into consideration, and not sympathy for the defendant or sympathy for Ashley Biggs. And everything that she's noble and throwing herself on a sword, so to speak, and all the charges or the felonies that the defense attorney asked her about, that yes, I committed those. Yes, I was a bad person in doing that. Those are all things that the defendant knows that she cannot be held accountable for, cannot be held responsible for today. Now, the defendant testified that, and all of this, when you keep in mind, remember, I said, please keep the concept of complicity, and I read to you, and so did the judge, the elements of murder and ag murder. Importantly, ag murder, because the things she testified to and the things on that recorded conversation goes to the planning, the prior calculation and design. She made that phone call, a burner phone. She purchased the minutes days before. And if you look at the exhibit, the phone records in there that are stipulated to, that phone was not used before, and that phone was not used after. That phone was used to make a call. Look at the records, you'll see calls coming in. You heard Matt Travis state that he called that number back multiple times. Officers, Detective Hitchings stated, they called that number. That phone had one purpose, and that was to lure Ashley to that place so that murder can take place. She followed Chad to the cornfield. And again, if it wasn't for her part, none of this could have happened. Her part was integral in getting Ashley to that building. Now, she admitted to in her testimony, there's multiple plans. There were multiple plans. She admitted to every plan under the sun. But again, this is an individual with an undergraduate degree in psychology and a master's in business. She's a very calculating woman. Every plan, but the one plan that she's sitting in court for today. There was a first drug planting plan with the marijuana, and these are plans now. And then there was a payoff plan that the first time Chad saw Ashley in court, that was the point of them going to get something to eat to try to pay her off. And then there's a second drug planting plan. But none of these plans will hold her accountable for what she's here today. And that's why she's able to sit up in that chair. Yes, I did that. Yes, I'm going to admit to that. She knows exactly what she's doing. She was able to sit here through this whole trial and hear all the testimony and evidence that you heard as well. And they both admitted that they identified Ashley at work prior to making that call. So they knew she was at work that day. The defendant testified that it wasn't reasonable to kill Ashley. It's not reasonable. How is that reasonable? She ended up going back to Brittany. Yeah, because they got caught. That was not by choice, that was by chance. And it absolutely is reasonable. Why is this going on? It's a custody battle. It absolutely is reasonable. And they know it's reasonable. When Ashley left the first time was not in the picture, who was Grace with? Chad and the defendant. So if Ashley is not around again, the biological mother, who do you think Grace will go back to? I mean, common sense and reason, Chad, the biological father. That will be the first place she'll go back to, especially since he just had her less than 6 to 8 months ago. That absolutely is a reasonable plan. What made it not reasonable is they got caught. Again, as the defendant told Mary Brinkman, and Mary Brinkman testified to, had the corn that had been planted was high enough, that car may not have been found for weeks or months. Had the plan would, according to how it was supposed to go, as Erica said in that recording, that was the perfect plan.
Felicia, I'm sorry to interrupt, ma'am. I'm going to need you to stop nodding your head or else I'll have to have you leave the courtroom, okay?
Oh, I'm sorry, I didn't.
No, that's okay. Is that
okay.
understood, ma'am? Thank you. Sorry, Felicia, didn't mean to interrupt. Okay.
That would have been the perfect plan. And they did everything to escape or trying not to get caught. Again, from putting the body in the far corner of that cornfield, couldn't go any further. Could not get the car any further if they tried. So even when the plan went awry, going back to the scene and try to clean it up, to hiding behind Chad's grandmother's house. Not just hiding, the first time they were just sitting behind them. And the police comes, and then they go behind a detached garage just further back. So it absolutely was reasonable to think that if Ashley was out the picture, that the defendant and Chad would get Grace back. Now, she also admitted to lying and being deceptive throughout the case. And this lying and deception was done when it was in her best interest. And what more is in her best interest than to get up on that stand? She needs you all to believe this drug planting plan. She said it. If you don't, she admitted that she's part and parcel. She's interwoven in what happened in the murder of Ashley Vick. She's interwoven in every part of it. And she said on that stand, If you go back there and you believe the plan was to murder Ashley Biggs, she is guilty. She lied and was deceptive when she got on the stand, testifying about, and LaPrenzie played some of the portions about what she said to Cindy Cobb. Now it's her voice, and she's saying, well, I think this, or I that. Not anymore. Well, I was just saying what I thought Cindy wanted to hear. I was just saying stuff to placate her. And again, is that reasonable? Why would she say stuff to placate a safe person in a safe place? And they're just having regular conversation. They're just shooting shit, talking amongst themselves. Why is she placating anybody? If she's placating Cindy, then what is she doing now? What is she doing now that she needs you to believe her? You want to think she's placating Cindy when they're having a casual conversation in a barn with the two of them and she has nothing at stake? But you don't want to believe that she's placating, being deceptive on a stand when she has everything at stake? Think about that. What's reasonable? When asked any question, she had an answer for anything, everything. She tried to explain away everything, even when asked about the plan. Yeah, Cindy knew about it. She was crossed. Well, how did she know? As soon as everything happened, Chad was arrested. She said, oh, we were at Richland. We went to Richland together, and that's when he told us. And again, don't take anything in this case for granted. Question it all when you get back there. Now, is it reasonable that Chad told them that when they went to Richland, when the defense attorney got out painstakingly in a 3-hour cross of Chad and a very long cross of Cindy, that as soon as Chad got to Richland, he started filing motions and wanting appeals that he was not guilty. Yet the defendant says when they got down there, he's just, yep, did it, just saying it, to everybody, her and his mom, yep, I did it. But on the other hand, immediately filing motions once he gets down there and appeals that he did not do it. What's reasonable and common sense? And I say this little stuff and it may seem little, but it's not. It's not. That goes to her credibility on the stand with everything she testifies to. Now let's get to this plan. This murder plan, is it a murder plan? Meaning, was the plan to lure Ashley there and kill her? Or was this a drug, a meth planting plan? It makes no sense. It's not reasonable. And the defendant said on the stand to Attorney LaPrenzie, you're good at your job. He's good at ferreting out lies and deception. Because once you tell a little one, and you started asking questions, it's like the snowball effect. It just grows and grows and grows and grows. And that's what happened when she was on the stand. That little one grew and grew and grew. It's the snowball effect. Now you have to answer all these questions. And to the point, it got not reasonable. And to the point, it got ridiculous. Please remember some of the things the defendant said about this plan on the stand. Now, one of the first things is, she was at that scene to make that call. That call could have been made from anywhere. That call could have been made from anywhere. That 30-second call or a minute call could have been made from anywhere. What sense does it make to bring your 4 children out? And as they kept pointing out, one is nursing. What sense does it make to bring them out in the middle of the night that you could have made that call from your bed? You could have made the call while you were nursing from your home. You want to know why she came out? Because Chad cannot drive 2 cars at one time. That's why. Chad cannot drive 2 cars. The plan was to lure Ashley there and murder her. Put her in the back of her car, drive to that cornfield. If the plan was to plant drugs, Chad could have done that on his own. Meth can fit in your pocket. He could have drove the car. He could have parked where she said they parked and walked over to the scene. Why was she needed? She was needed because that wasn't the plan. She was needed because, again, Chad cannot drive two cars. The defendant also testified that he had on the Cobb cable shirt, the neon Cobb cable shirt only, and jeans when he got out the car. Okay. She testified, and in the same breath, she testified that, quote, Chad not being seen was a crucial part of the plan. Now, we know Chad said he had on camouflage. This was on up under his camouflage. But on top of it, he had on camouflage. Okay. The defendant testified he got out of the car with a green shirt on, a green work shirt on. Look at this shirt. It is crucial part of the plan that he not be seen. And he's gonna get out of the car with a neon green shirt on. And what does it say on there? Cobb Cable Company with a neon green shirt. Reading Cobb Cable Company. Now we know he had this on up under. He left his killer outfit, the jacket in the car. And we see the blood and the dirt on this from when he put Ashley in the car. So we know he had this on. It was just up under this. But just think about that part. And then she was asked if the building have cameras. And she didn't know if the building had cameras. So you don't know if the building has cameras. And he gets out with the book bag that she had no idea the contents of. But look at this book bag. Again, do not take anything in this case for granted. Question it all when it comes to the defendant's testimony in this drug planting plan. So it's this book bag. It's only so big. So he would have had to get out that car with that book bag, these pants, a grown man's pants, and then a grown man's jacket. Okay, not just that. These zip ties. In that book bag. And not just that. There was a taser, that knife, duct tape, face paint, the gloves you saw. Makes up this picture. And look at the size of that book bag. If it fits, it's squished. Is that a plan to get out of a car with all of that squished in a place you don't know that have cameras, that you don't want to be seen, yet you're changing your whole wardrobe at that location, your entire wardrobe? Remember, she said he got out with the shirt and a pair of blue jeans. He had to put on camo pants. He had to put on his face paint. He had to put on his hat. Remember, Chad said he had the taser on his belt. Does that sound reasonable? You don't want to be noticed, but you're going to change when you get to that parking lot? And if that's the case, even if you go with her plan, he's getting out the car with a backpack stuffed to capacity. This is a drug planting plan. Remember, it's meth in your hand. In addition, she testified that, you heard testimony, that the pizza was ordered to a closed business. Where was Ashley gonna go to deliver this pizza? Go to the back door. Where was Ashley gonna go so they can put the drugs in her car? So Trad can put drugs in her car. She can't go in the building. That's an open area. How is he gonna sneak around and put the drugs if she cannot even go in a building to get out of sight so Chad can surreptitiously go and put the drugs in a car? It does not make sense. It is not reasonable. And that's because that was not the plan. The plan was to lure her there, ambush her, which they did, taser her, zip tie her. The conversation under the tree. When you go back, there's a drone video of the scene. Please take a look at that drone video of the scene. And you were there. The front, you go around back, there's one distinctive tree in the back. There's the big tree, and she talks about that. When Chad says we were under a tree, we literally were under a tree. That is behind that building where Ashley Biggs was murdered. Please look at that drone video. You cannot see that tree from the front. The only way you know that tree is back there is to go back there. But the defendant says she was never at that scene. She only parked and stayed across the street. And I want you to take into consideration for the murder plan versus this being a meth planting plan or a drug plan. And before I go into the circumstances to take into consideration, I want to talk about the first plan, because they kept saying the first plan didn't work. Actually, the first plan did work. Everything they did work. They were able to plant the marijuana, I believe was the first go round. They were able to plant that in the car. Everything they had to do worked. Everything they had control over worked. They were able to plan it. They were able to get the police to come out. It's just what they did not have control over is how the police would react to what was in the car. So they had done what they set out to do in the first plan, okay? And they did that during the daytime. They didn't have to call anybody anywhere, you know? They didn't have to go deliver a pizza to the back door to a closed business in the dark. These circumstances didn't exist during the first one, and it worked, meaning they were able to plant the drugs, if that was the plan, just to plant the drugs and get her in trouble. No matter how many times they plant drugs, they'll never be able to script the ending. They can't tell or foresee what the police do. All they can do is plant the drugs. And I say that because in that recorded conversation, again, listen to her words. If we can do this, this may be too risky. What do you mean? You did it the first time. Think about it, please. And again, question everything. Do not take anything that happened in this case for granted. Now, I'm going to leave you with the defendant's own words. These are some of the excerpts that we played throughout the trial. You're more than welcome to take it down and listen back there. But these are some of the excerpts. Now, before I play them, I want to talk about just a little more stuff the defendant said on the stand. And one thing is quite clear. If you believe the plan was for murder, then she's guilty, because she specifically said there was a plan. There was a plan. As opposed to the meth planting. The other thing, when you get back there, look at exhibit number 127. Just look at it. To plant meth, do you need gloves with knuckles? To plant meth, do you need a knife? to plant meth, do you need zip ties? Look at this neoprene mask. Common sense and reason. If you see someone dressed like this with face paint on, are you gonna think they're coming to plant meth? Are you gonna use your reason and common sense? I'm not scared of a person just like this. They're just coming to plant some drugs. He wasn't wearing this outfit by accident. He was wearing this outfit because of the plan, because they knew what they had to do that night and what they were going to do that night. I hate to show this, but Ashley Biggs did not get in the back of her car like this from a plan to plant meth. This was a plan to murder Ashley. This is not a meth plan going wrong. This is a murder carried out. And where are the drugs? You heard testimony from agents from BCI. There were multiple search warrants carried out. The defendant's car that they found behind the detached garage where they were hiding in was actually towed to their facility. They took their time with that one. Where are the drugs? Ashley's car was searched. Their home was searched. No meth was ever found. Where are these drugs? One of the things that you'll hear the defendant is saying is that every time she hears sirens, she looks over her shoulders. Every time, and you'll hear that throughout that recorded conversation. And look how she talks about it every time. Is she worried about the felonies that the defense attorney talked to her about? That absolutely, I'm guilty of those that she knows we can't prosecute at this point in time. No. Chad has that information, has that knowledge, has that power of knowing that she's involved with the murder of Ashley, not about a meth. Not about meth. And the defendant does it back to him. She uses the children to keep over his head. I have to be out. Listen to the recording. I have to be out to take care of these children. They're going to get adopted away. Again, you cannot use sympathy to take this into consideration. You cannot use sympathy. She's so worried about Chad. Chad has nothing. You heard the testimony. They were part and parcel of selling off his business. No money, no anything, just information. Common sense and reason. Would she be that concerned, that hell-bent in that recorded conversation about hearing sirens, looking over my head? I need to get some insurance if Chad plans on throwing me in jail. Come on. And one of the last things before I leave you with Erica's words are, in opening statements, just like the judge stated, the purpose of closing arguments, to show you how we've proved this case beyond a reasonable doubt. In opening statements, if you remember, the judge stated, again, it's not evidence, but it's a roadmap to show you what we think the evidence will show, what we think testimony and evidence will prove during this case. Not one time, and Erica was questioned, not one time did we hear anything about a drug planting plan. During any time with the defendant, during the pendency of this, during any time during opening where this is what we think the evidence will show. This is her bread and butter. This is it. This is what she's hanging her hat on. This drug meth planting plan. I mean, that's it. And I hate the heart, but she said it. If you don't believe that, I'm guilty. Because I'm absolutely part and parcel of everything Chad did that night. And we did not hear when Chad testified, not one question asked of him. Who else are you going to ask? And jury selection, the defendant said, don't hold it, the defense attorney said, don't hold it against us because we have to ask the hard questions. We have to ask the questions that seem difficult or seem like we're badgering, but we have to do it because it's on behalf of our client. What question was asked? Hard, easy. There were no questions asked. Is that because she sat there and heard the testimony and evidence and conformed her statements to that after the fact? What about Cindy? She said she told Cindy the plan. Not one question. Chad was cross-examined for over 2 hours, as was Cindy. Again, don't take anything in this case for granted. Question everything when you go back there. Not one question about the crux, the sum and substance, about her defense. Everything else under the sun was asked. Ladies and gentlemen, this defendant, Erica Stefanko, is guilty of murder and aggravated murder. She tells you that.
Cookie or something. Right. Something to eat. And that, so yeah, he wasn't any of that. I actually got a good picture, which I still got to get. I guess that one again, which I still have to get pictures copied. And then he goes into, and he says that you guys are allowed to bring up whoever you want, whenever you want. And I have to give him all the tools immediately, or he's going to, how do you phrase it? I don't know about my involvement with Ashley. Like cookie or something. Right. And in fairness, like some of the stuff that was going on under his roof, like that, this is the part that really gets me that I don't, that sort of like the same way that he's like, okay, well, you know, like today he's like, well, I'm here because of you and it's all your fault. And I'm like, bullshit. How are you going to say that? Like, I get that if everything had been told exactly as it happened, then we both be in prison right now. I don't disagree with that. That's totally the truth. But for him to say that, you know, oh, I would have been there because of you, except if it weren't for you. He came up with how to do it. He executed almost all of it. The part that he executed went totally awry. I mean, he would talk about, I couldn't really, there's no way for me to say it over the phone, and I didn't want to make a problem for him or make him angry for his appeal. But he was so like, he would get this look on his face and be like, yeah, I'm going to, if this goes through and I can do this, I'm going to keep her skull and trophy. It's not inclusive and it's not fair. I know that he may have asked me, because he's all the time, he's like, oh yeah, well, I told you I wanted to go home. And I'm like, when did you ever say that? Because I remember the conversation that we had under the tree, and he's like, under the tree, because we really were literally under a tree having a conversation. Well, when he refers to it that way, like the time of the tree, that's what he's always talking about. He's like, you know, if I do this, there's no turning back, blah, 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 blah. And went forward from that.
Before I go on to the next one, if I do this, there's no turning back. It absolutely is. They've done it before. If you're talking about a drug planting plan. Again, listen to it and think what's reasonable. about how she's talking and what she's talking about. It's the murder of Ashley Biggs.
Yeah, I mean, not, I mean, I don't know what transpired. Because I mean, I think I seen him, I think Jay and I stopped out there Monday. And everything seemed peachy keen. And you guys are getting ready to go on to Disney World and stuff. I mean, do I think it took two of you to get to where he is today? Yeah. Well, that, I'm not disagreeing with that, but it took two of us. It wasn't, he's trying to put it all on me, and that's not, and the reason that I have a problem with that, aside from just like, I mean, I don't think that that's fair. I don't get the, I mean, when he talks to me, I don't get the feeling that he's trying to put it all on you. When he talks to me, he does. Like, I would not have ever even been there at work for you. And like the situation with Ashley was because of me. And he knows ultimately, physically, I don't know how you want to term it. He's responsible for that act. Then that comes into a balance. So that, I mean, that's why I was like, okay, I was like, because the first thought that went through my head is immediately I'm like, well, if this is what's going to happen and I'm going to lose the kids and I'm going to jail and this is what's going to happen, because to me it was like one of two things. Either he's bluffing and he really never really do that, or he plans to do it anyway. That was the fact that he put it there instead of just having a normal conversation with me and saying, you know, I'm not ready to put it on the floor. Yeah, I keep wanting to do that. Yeah. Instead of just having a normal conversation and saying, look, I'm not ready for this. I don't want to be your enemy. I want to work with you with the kids. And I mean, I can't necessarily expect him to be able to articulate that given his state of mind. But I mean, the way he went about it, unless his real intention is actually to throw me in prison, in which case I need to make some arrangements to figure out what's going to happen with his kids, because every single one of them is going to get adopted out except for Lily, because obviously she's got somewhere to go. And like, maybe you guys be a cop. But what's going to happen with Faith and what's going to happen with Theater? I mean, I don't have.
And again, based on her testimony that you heard on the stand, where she said if Chad's plan is to throw me in prison, I don't know if he's bluffing. She testified. If this is an act murder, if I was guilty of or did the act murder, I would plead. So what's the problem? She wants you to believe she would plead for an act murder, but the smaller charges that she sat and lied to Officer Hargett in his face when they caught her and continued to lie throughout this case about the smaller felonies that she was questioned about on direct, she lied to get out of them. She was deceptive to get out of them, but she wants you to believe, oh, for aggravated murder, oh, I would have pled to that. So what's the problem? What is the problem? What difference does it make if she would plead if it's an aggravated murder? She absolutely would not plead if it's aggravated murder. And again, this is little, but it's in the whole scheme of things of her testimony and her credibility of her testimony.
And it's not like I don't have a problem with church, and it's not like we're on different pages, you know, from that perspective, but that's what he has on his own. Oh, he actually got that tattooed on there? Yep. Interesting. It's like Jace. It's very, 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 very close. It's about half. What is that? Truth and love? True love. And that's what Jace says. Oh, okay. I mean, other than this is different, the hearts are a little bit different. This is Jace tattoo. Well, that's good. And I'm like, how did you do that without going into convulsion? That's a good question, because he never has his back finished. He said he laid down. He's got 2 here now. Jay's like, that is enough with the tattoos. I forget what, this is in lab too, and I forget what. It's religious, whatever it is. Yeah. But anyway, from my perspective, I can't, like I said, I can't have him. And if it really is his intention at some point to put me in prison, I'd like to know about it, because I have some arrangements to make. I'm not going to go to prison. I'm not going to have someone else raise my kids. and just stand by and I'm just gonna be in prison for 15 years or however long it's gonna be. Makes me feel like I need to take out a life insurance policy, to be totally honest with you. Cause I'm, like, I know he's talked about, oh, I'm gonna do X, Y, Z, well,
Not at any point does the defendant ever throughout her testimony or throughout the recording say he doesn't have the power to put me in prison. Because he does, because he knows what she did. Never once does she, oh, he can't do this. I didn't do anything. Never once in that recording does she say, I don't know why he thinks he can do this. I didn't do anything. No, she is scared of what Chad is going to do because he has that knowledge and information of what happened that night.
yeah, because, yeah, we do, because it took both of you to get where you guys are today and where he is. And it's not unreasonable to be like, well, okay, you get to go scot-free, why does he have to now bear this burden? Right. It's not that I don't understand that, it's that it was not knowing that had to be your perspective was not a place I want to be. And I think if you know anyhow we're doing this, I don't think you would have. No, it's very true. And from if he had said, the thing that he and I really butt heads against is all the bullshit that we did that we shouldn't have, where we could have gotten in trouble. There was always something that I would say to him, which I said to him repeatedly, whether he remembers or not, with the Ashley situation. You know what you can do and what you can't. If this is something that you think you can do, then I'm okay with it and I agree with it. If you can't do it, then obviously you shouldn't do it. And I always threw the ball back in his court. I don't think those are the exact words that I used that night because we already have been over that so many times. We would fight about it. I'm like, this is the only way this situation is going to go away. And I feel like he really felt, I didn't know that at the time, but he really felt pressured by me to do something about it. Because I felt like he was the only person that could potentially do something about it. And he didn't tell me I can't do it. If he had said I can't do it, then never would have proceeded. If he had said I can't do this is something that I can't do, there's no way in hell I would have go forward with it. I foolishly threw the ball in his court, let him make the determination as to whether he was capable to do something that I should have had the good sense to know you just don't ever try to do. So that's when I'm like, I will admit to my fault in that. It's like, yeah, I should have at that point said, this is too risky. That point, whatever percent is too much. Yeah. Because I just seen him get away with so much crazy shit that I thought he'd get away with anything. If he had gone, if what was supposed to happen that night had happened, then he had a perfect plan, but it didn't go the way it was supposed to go at all. And why that is, I don't know, because he's told it to me 2 different ways. It doesn't matter now. Yeah. But yeah, again, that's why, you can't really function in everyday life if you're looking over your shoulder every second. Every time I hear a siren, I think they're coming for me. And that's something that I'm going to live with, but I don't need him to contribute to it. And if his goal is really to do that, then I need to know it. If his goal is really to do what he needs to do for himself without sacrificing everyone else, because regardless of how he feels about me, and I'm not trying to say this in a manipulative kind of a way, it's just the fact of the matter. Kids and I are part and parcel. And unless you guys think you have some way that you can take care of them, for him to see the kids, I have to still not be in prison.
In that section, she said, if what was supposed to happen that night happened, he had the perfect plan because he told me 2 different ways. If your plan is to plant meth in a car, how many different ways it's just meth. Think about how in depth and detail she's going. That's because the plan was to murder Ashley and how he was going to go about doing it. That was the two different plans. And then she goes on to say, I'm not trying to say this in a manipulative way, but the kids, I need to be out. I need not to go to jail if I need to take care of the kids. Again, Chad is using his information to try to get the kids for his family to see, and she's using that to try to keep Chad quiet. If you tell on me, your family's not going to get them, they're going to get adopted out. And Chad testified that was part and parcel of the reason he pled in the first place.
I mean, go forward and raise the kids. At one time, I mean, you told me face to face that you made the phone call and you set the meeting up. I mean, you had told me, and there's no lie in that. Like I said, Chad said, this is what we're gonna do, and this is your part in it, and I carried out my part in it. I did exactly what he told me to do. And it wasn't because he was forcing me to do it, or like he had a gun to my head. It was because he said, this is your part and this is what you're gonna do. Which is how it always was when we did something we were supposed to do. And I did everything he told me to do, and I fucking gave it up. But I mean, he's had, because stuff did come out in counseling, and you openly admitted to both, evidently him and I, some of the transgressions with Grace, which some of them he knew about and others he did not. Well, I told him his one dumb act doesn't define him as a person. And, he's like, you don't even feel bad about what happened to her? And I don't know that I responded to it, but I feel bad about what happened to everyone else because of what happened to her. No, I don't lie and tell you that I feel bad about what happened to her. No, I really don't. Yeah, I was gonna say. Knowing everything that I know about her and Grace and what kind of a person that she was and where her life is going, do I feel bad about what happened to her? Not really. Even the moments that she went through before her life ended, no, I kind of feel like.
Again, listen to what she's saying in the calls, in the recorded conversation, even the moment she went through before her life ended.
So, well, my intention is not to make things harder for him. Trying to work with him. But the worst thing he could do is try to put something like that over my head because it's already over my head already. And do I feel bad about what happened to her? Not really. Do I feel bad about what happened to everybody else? Absolutely. Would I take it back if I could? Yes, it would. Well, yeah, so would he. Well, I don't think there's any question about that, because he asked me that. It's like, you don't even feel bad about what happened to her? And I'm not gonna lie, I don't. I don't.
Ladies and gentlemen, the state puts forth that we have proven beyond a reasonable doubt that this defendant is guilty of aggravated murder and murder. Thank you so much for your time.
Thank you, Attorney Easter. We are going to have a brief recess, so everyone can use the restroom if they need to. We will recess for 10 minutes and then come back, okay? Get Adam in here.
All rise.
Okay, thank you. Go ahead and be seated. You ready, Christy? Okay, we're going back on the record. State of Ohio versus Erica Stefanko. It is 11:52. It is now the defense's opportunity for closing. Go ahead, counsel.
Good morning, ladies and gentlemen. It's been a long road, but we're here at the conclusion of the case. We want to thank you again for your time and your patience and your diligent attention. We've been watching and we have noticed that you've been paying attention. You've been writing down notes. And I know that I, and especially Erica, really appreciate you taking this serious matter seriously. This is the second part, as the judge told you, of closing arguments. This is the middle part. So Miss Easter had the first part, I have the second part, and then Mr. LaPrinzi, I presume, has the third part. That third part is notable because it's the only part of closing arguments that will go uncontroverted. So someone like me isn't up there fact checking or logic checking the statements that he makes. We're not worried about that because we know that you all will be fact checking and logic checking what he says. We have faith in all of you. Now, Miss Easter and I presume Mr. LaPrinzi have attempted and will continue to attempt to frame your job or your decision inaccurately. They're going to try to frame your job and the decisions that you need to make on this case as, we, the defense, need to prove beyond a reasonable doubt that there was a plan to plant meth. They're going to frame it as a tug of war. On this side of the rope, there was a plan to kill Ashley. And on this side of the rope, there was a plan to plant meth. Do not be fooled. We have faith and trust that you will not be fooled. You will not be fooled by assertions that Miss Easter made that the defense didn't ask the correct questions of their witnesses. They have the burden. The state and the state alone has the burden of proof. I told you in voir dire, the defense doesn't have to do anything. The state has to do everything. And they're going to try to fool you to make it look like we have a burden to prove things beyond a reasonable doubt. It's just not true. You have those jury instructions in front of you, and I know you'll refer to them. The only thing that you have to do, your only job, is to decide whether they have ruled out logical doubts in this case. If you find a logical doubt in their presentation of the case and they haven't ruled it out, your job is done. You come back in here from the jury room and you say not guilty. So let's talk about logical doubt. Miss Easter said that Erica's got an answer for everything. Man, everything she said up there, she's got an answer for everything. She's got it all covered. I ask you this, does the state have an answer for anything? Which theory is more logical here? We never once, throughout this testimony, heard Chad Cobb or any other witness say that there was a plan for murder. Look through your notes. Listen to that tape that they keep playing little snippets from. You won't hear it.
It never happened. They want you to believe there was a plan for murder, yet it was never said, and certainly never proven beyond a reasonable doubt, which is what they have to do. When you look at this case logically, the verdict has to be not guilty. It just has to be. There's so many logical doubts that they cannot rule out because the logic in this case rests on the side of the defense. The state side is completely illogical. It's much more logical that the plan would be to plant drugs rather than murder. They told you themselves that this stemmed from a custody situation, that this plan was part and parcel with getting Grace back, getting custody of Grace back. How does a murder or a plan for murder do anything but the opposite? Don't take my word for it. Look what actually happened when Chad Cobb and Chad Cobb alone killed Ashley. What happened? Immediately. Who's the prime suspect? Chad Cobb. Where was the pizza delivered to? Here's the address. Here's all kinds of evidence. They catch Chad Cobb almost immediately. And what happens then with the custody battle? What happens then with Grace? She goes back to Brittany Dunson. It's completely illogical. The foundation of the state's case is illogical. A plan for murder does not get Grace back. The plan for murder, as they call it, got Grace right back to Brittany Dunson and got Chad Cobb in prison for the rest of his life. It's much more logical that the plan would be to plant drugs rather than murder because they did it before. I'm not telling you that. Erica's not telling you that. There's a police report. In that police report, suspect number 1, Brittany Dunson.
We approach.
Yes. Sidebar. Objection overruled. Go ahead and continue, counsel.
Thank you, Judge. They are objecting because they are afraid of the
Now,
evidence in this
okay,
case.
Are you serious?
I'll move on.
Judge,
I'll move on. The
We'll
first
strike
incident,
that.
That's unethical.
The jury's going to strike that.
the first drug planting incident resulted in a police report. The suspect of that alleged crime was Brittany Dunson. She got up on that witness stand and told you she was accused of having marijuana. The reporting party in that case was whom? Erica Stefanko. She made the call to the police to say there were drugs in that car. Another person involved in that case was Ashley Biggs, Brittany Dunson's girlfriend. Erica makes that call and makes that accusation in an attempt to gain an upper hand in the custody situation. And that prior incident that is documented by the police, this is not a story that she's telling, documented in a police report, shows why the drug planting plan is much, much, much more logical than murder, because they had done it before. Erica is the caller. Erica was the caller in the first case, first drug planting case. She's the caller in the second drug planting case. A drug possession charge for something stronger than marijuana solves the grace problem. It solves the custody problem. Murder does the opposite of solving it. It's much more logical that Chad and Erica would go from marijuana to meth, rather marijuana to murder. That makes no sense. No one would plan that. And it was not planned. It's much more logical that Chad Cobb was never to be seen in that parking lot that night on June 20th and 21st. That's the key to the plan. That's why there's all of the camo. That's why he's got his face covered. That's why he's wearing makeup, head to toe in camo. If he wants to kill Ashley Biggs, why would he care if he is seen? Why would he care if she knows who he is? It's illogical. Their premise for why and how this happened is completely illogical. You only wear camouflage to not be seen. And she showed you again that head to toe. There's not 1 inch of Chad Cobb showing in his outfit. Why would he care if she saw him? He's going to kill her. She can't tell anyone, right? He's only camouflaging himself so that he is not seen, so that he is not linked to the drug planting. Miss Easter took great care to allege that this backpack that has an extension on the top here, and you guys will be able to play around with this, could not fit all of that stuff that Chad had on and with him that night. You're going to have this back in the jury room. You're going to have all of his stuff. You're going to be able to wind up those zip ties how they were stored. Put it all in this bag and see if it fits. When it does, because it fits, you know what that is? Logical doubt. And you know what they have not done? Ruled it out. Use the evidence back there to show that they have not ruled this out. There is no physical evidence of any kind that you're going to see that links Erica to this. If their theory is to be believed, something would have shown up on all of that stuff that Chad had in this bag. If she packed it for him, as Chad Cobb testified to, her DNA would be all over it. But there's not. It's illogical that she would have such a big role in this and help and plan, yet there's no physical evidence whatsoever tying her to the crime. None. The logic in this case rests on the side of the defense. Who got the GPS tracker? Chad. Who put it on their credit card statement? Cindy. Not Erica. Chad. Mr. LaPrinzi, in his cross-examination of Erica yesterday, said that the jury would be fools to believe you. The jury, you all, would be fools to believe what she's saying. If you have logical doubts about the state's case at this point, Mr. LaPrinzi, the state, the government thinks that you are a fool. A person that sees this thin evidence and ridiculously questionable testimony and finds holes, or finds flaws, or has questions, or has logical doubts, is not a fool. All that person is doing that finds those holes and flaws is paying attention. You all have been paying attention. And when you discover the problems with the state's case, the state thinks that you're a fool. The defense does not think that you're fools. The defense thinks that you've been doing your sworn duty, which is just to pay attention. That's all you have to do in this case to find innumerable holes that acquit Erica. Now, speaking of a lack of logic on their side, let's talk about Chad Cobb. The state is in a position right now that is very odd. They charged this man with the death penalty. They prosecuted him. They came to an agreement where he would serve life without parole. And throughout this case, they are defending Chad Cobb. They are propping up his testimony. They are making excuses for Chad Cobb. Now, I get it. That's their star witness. They got him all the way from prison, brought him in here, put him up on that stand in an attempt to implicate Erica. So it makes sense that maybe they'd have to prop him up and defend him on some level. But this man is serving a sentence of life without parole for a crime that Mr. LaPrinzi prosecuted. And we're supposed to listen to anything that this man has to say. And they want you to believe that it's credible. And that's before we get to the point that almost immediately after he took full responsibility for this, he tried to withdraw his plea. If he had been consistent throughout and said, look, I killed her, I know what I did, I guess maybe they'd have a better argument in their unabashed defense of Chad Cobb. But when he tries to withdraw his plea and tries to immediately say, well, no, I didn't do it. No, I didn't kill Ashley, despite a mountain of evidence here that shows otherwise. Despite the state themselves disagreeing with him and saying, no, he did it. But yet they still tried to defend him. Not only did he change his mind right after, but he's currently engaged to this day in efforts to change his story and withdraw his plea. That's the state's witness. They brought him here from prison to walk into this courtroom shackled and in orange, and they sat him up on that witness stand. And what did he say? He looked all of you in the eyes and said, I didn't do it. That is a gigantic issue for the state of Ohio in this case. The fact that their star witness in court and in front of all of you under oath said, I didn't do it. A knowing, voluntary, intelligent plea colloquy. This is attached to a death penalty case. This plea probably went on for an hour. Question after question after question posed to Chad Cobb by Judge Amy Corrigal Jones. Never once said anything about Erica. Never once hesitated. I don't know. Maybe I shouldn't plead. He pled. He accepted full responsibility. Mr. LaPrinzi was there for that. You can be damn sure if he had questions about the voluntariness of that, he'd have stepped up and stopped it. No issues. I am guilty, guilty, guilty. Aggravated murder and murder. And he sits down in that chair and he looks all of you in the eye and says, I am not guilty of aggravated murder and murder. That's the state's witness. And when Mr. LaPrinzi asks Erica in cross-examination how she knows that Chad committed the murder, she gave a great response, in my opinion, because he pled guilty to it. And then an absolutely shocking moment occurred. We saw Mr. LaPrinzi do his best Chad Cobb impression. Well, no, he actually just pled guilty to the charges. He didn't say that he actually did it. It was ridiculous when Chad Cobb did it, and it was outrageous when Brian LaPrinzi did it. That is all the logical doubt you need right there. The state's star witness who accepted full responsibility, serving life without parole, comes in here and says, I didn't do it. I think the state has been hypnotized by Chad Cobb to the point where they're parroting his own ridiculous excuses for why he's saying what he's saying now. I half expected after that Mr. LaPrinzi to say something about Disney World. He's hypnotized. You will not be. You don't have an interest in how this thing plays out. You're here to judge the credibility of witnesses and to hold them to their burden, to rule out logical doubt. And we trust you to do that. They make excuses for him as if the charges can be separated from the conduct. The charges that he pled to are the conduct. A person does not plead guilty to aggravated murder unless they committed aggravated murder. Chad Cobb pled guilty. Erica pled not guilty. Chad Cobb said, I don't want a trial. Erica said, give me my trial. Mr. LaPrinzi used the word semantics. Well, this is just semantics. Ridiculous. These distinctions are not semantics. Pleading to the crime versus doing the crime, that's not semantics. That's about acceptance of responsibility. That's about credibility of a witness. Semantics. You'll have jury instructions. You have jury instructions. And they're full of numerous detailed definitions of nearly every word that's important in this indictment and in this case. The judge took a lot of time, and her staff took a lot of time putting those jury instructions together, defining all of these critical terms That shows you that this is not semantics. This is important. They're defining words and legal concepts, but the state, they just want to whitewash all that. They're just words. No, you will not be fooled. I would ask the state, what was Chad Cobb's plan then? Because we haven't heard it yet. We heard Erica tell us what the plan was, but Chad Cobb said there was no plan for murder. How can they proceed on aggravated murder and murder under a complicity theory against Erica if the principal offender didn't have a plan? They're creating a plan against Chad Cobb, and they're trying to extend that to Erica. They can't do that. They cannot do that. Please think back on your testimony, look at your notes, and find where Chad Cobb said that there was a plan to kill Ashley. Find it. You won't. It doesn't exist. He never said it. His plan was to go to Disney World. Chad Cobb killed Ashley Biggs alone. No one is disputing that, other than the star witness in the case that they're expecting you to rely on, Chad Cobb. Miss Easter, in her part, said Chad Cobb killed Ashley. He did it. Their own witness is denying that. That's illogical. That is a massive doubt that they have just left out there with no explanation. Where's the plan? Where's evidence of the plan? Where's testimony of the plan? There isn't any. That creates logical doubt. They're left it out there. Not guilty. They can't rule it out. She's not guilty. Now let's talk about the plan some more. Listen to the tape. They played you snippets here and there. I completely agree with the state. We want you to go. It's long and brutal and whatever. Listen to the whole thing. Try to find in the entirety of that 3 hours where a plan for murder, that's what they gotta find here. Beyond a reasonable doubt that there's a plan for murder. Find one instance on that over 3 hours of tape where a plan for murder is discussed. I want you to do that, but I'm gonna spoil it for you. You won't find it. It does not exist. No testimony about a plan for murder, no evidence of a plan for murder, including an over 3 hour freewheeling discussion about this whole situation that never once says anything about a plan for murder. They're done. Logical doubt. There was no plan. They have not ruled that out. In fact, I would say that's the most likely thing. Not only have they not ruled it out, we are proving it that there was no plan. She's not guilty based on just that alone. You won't find talk of a plan for murder because it's illogical to have a plan for murder. As I've stated, the most logical plan here is the plan that they had already tried once. You plant drugs. The way to get custody back, if the sides can't be reasonable adults about it, which it sounds like they couldn't, if you can't make an agreement, try to buy her off. Chad tried that, didn't work. Try to get Ashley or Brittany in trouble. They tried that. It didn't work. And you heard testimony that part of the reason that it didn't work is because it was marijuana. And despite what Cindy Cobb thinks about that drug, the police and everybody else in this state don't think it's that serious. So they needed to go to a more serious drug, a drug that if you're found in possession of could be a felony. That is much more logical than this huge leap to murder, which would get the cops immediately on Chad Cobb. Brittany Dunson shows up is at Domino's. Detective Hitchings gets there right off the bat. Ashley's still missing. We don't know what happened. Walks in. Immediately out of Brittany Dunson's mouth, it's Chad Cobb. No doubt. And it was Chad Cobb. And he's arrested a short time later. A plan for murder never gets grace back. As it relates to the plan, Ms. Easter talks about the corn. And I had not thought about that until she said that in her closing argument. Well, you know, the corn wasn't high enough, and that had been, if it had been higher and grown in more, probably would have gotten away with it. If they planned this out and they planned to put her body there, if it was anything other than Chad Cobb on his own, freaking out, killing Ashley, taking her body alone, putting it by his parents' house, if there was ever a plan, would they think to look at the height of the corn? Would they think to look at a place where that woman that lived nearby could just look out her kitchen window and say, there's a car in that field? Does that sound like a plan for murder? Does that sound logical to you? No. There's no plan, and it's not foreseeable for Erica to think that Chad would ever do this. Aside from everything that I've already told you about, that this plan makes no sense, it doesn't solve the problems or whatever, there's no shred of evidence or testimony in this case that could show that Erica could reasonably foresee what Chad was about to do. Not only was there not a plan, but he was never supposed to be seen as part of the actual plan. Never thought that he was capable of something like this, and it would be foolish to do it because not only would it get him in trouble, which it did, but it wouldn't get Grace back, which it didn't. When he got out of that car, he was dressed normally, and he had everything that he needed in this bag, which fits everything that he had with him. They've talked throughout this case about a getaway driver in a bank robbery to help them prove their complicity theory. Huge issue with that. The getaway driver for a bank robbery drives the robbers up there, and the bank robbers get out with guns, with masks on. They go into the bank. Something goes wrong. A guard gets shot. Heck yes, that getaway driver is charged with murder. Because it's foreseeable that when you're holding up a bank, somebody could get shot. There's armed guards in there. There's cops in there. That's a completely different situation than what we're talking about here. And you guys are smart enough not to conflate those two. He didn't get out of the car with that whole getup on and a gun in each hand. He didn't have a gun. She didn't know what was in that bag. The plan was to plant meth. The plan was for him to never be seen. And the plan was for him to run out of there. There's never a plan, and it wasn't foreseeable for her to see a plan in Chad's actions. Let's talk about Detective Hitchings. Now, the police have a tough job. It's a difficult job. It's a job that I don't want. And this is a big case for New Franklin. And I'm not giving him a hard time for some of the mistakes that he made, but when there are certain assumptions that are made and followed through with for years and years and years. We got to hold him accountable. He testified on that stand that he believed Erica was involved from the quote, get-go. And he never let it go. All of the evidence that she didn't have involvement in it, all of the evidence that there was no plan that has come up throughout the years, he suppresses it. He minimizes it. He casts it aside. Anything that would show that maybe she had some knowledge or there was a plan, even if it comes from a convicted murderer who's now saying he's not a convicted murderer, that's propped up. That gets its due investigation. All this other stuff, no, that's just coincidence. But if Chad Cobb, the least credible person in this case, says she had something to do with it, she knew about it, we had a plan, I'm going to believe him. Oh, and by the way, go talk to my mom. And let's talk about his mom. Cindy Cobb basically admitted that she never liked Erica. Because no one would ever be good enough for her baby. No one could ever be a good enough person for her sweet Chad Cobb, who she still supports, who she still believes and has hope that he is getting out. I want you to listen to the tape that she made. Again, I want you to listen to the whole thing. I want you to find in there where Erica is talking about a plan to kill Ashley. It's not in there, but you judge for yourselves. Don't listen to what I'm telling you. But you know it, there's not in there. It's not in there. You know why? Because they'd be playing it over and over and over. They've been playing excerpts from that tape, the same ones, over and over and over. And in all of those repeated playings, what you never once heard was this is what the plan was. The plan was for murder. You never hear it. But judge for yourselves. What you will hear on there is Erica say things like, the part he executed went totally awry. If the plan was for murder, how did this go awry? If the plan was for murder, the plan was successful. If the plan was to plant drugs, the plan went awry. Logic. They cannot rule these statements out. Erica says Chad on that tape, listen to it. Erica says Chad, quote, is turning the situation into something it is not. If that's not drug plant to murder, I don't know what is. He is turning this plan that they originally had, that then he went in that parking lot and killed her without her knowledge, without telling her he was going to do that. He's bringing her in to help himself. He has hope. He has belief that he is getting out. She says on there, quote, this is what happened and you're going to do as I say. That's just his personality. Quote, I had no control. If I step out of line, what's going to happen? From Cindy Cobb, quote, I think he just snapped. Erica, I could see him snapping. Talk to me a different way right after it happened. If the plan was for murder, then what is he snapping about? What is the snapped? If the plan is for murder, he was controlled. He was diligent in following the plan. It didn't go awry if the plan is for murder. Everything on that tape, not only is there no mention of murder, but it all logically refers to a different plan other than murder. A plan for murder cannot go awry when Chad Cobb commits murder. Logic. Erica says, quote, if he had got what was supposed to happen that night, yeah, happened, then he had a perfect plan, but it didn't go the way it was supposed to at all. And why that is, I don't know. If the plan is for murder, I'm sorry I keep saying this, but they have never addressed this. If the plan is for murder and he murders her, then how has it not gone according to plan? It would have gone exactly the way it was supposed to. She says things like, I'd be in prison if the truth came out. Absolutely. She told you why. She committed crimes here. She's paying a price right now. She's in jail. Always looking over my shoulder. Damn right. She's involved in this thing, and Chad is trying to now make up this plan that involves her. I'd be looking over my shoulder too. She says, I did my part of it. She's the caller. She called when they planted drugs the first time. She called when they planted drugs the second time. She did her part of it. And she's a bad person for doing those things. I will tell you that. Getting Brittany and Ashley in trouble, committing felonies to do so, that is not good behavior. But you know what else it isn't? Aggravated murder or murder. Miss Easter talked about Chad having power. I agree. Chad had power. Chad had real power until the defense started to look into it, until Eric asked for a trial, until he had to get up on that witness stand, and now he's powerless. The state star witness has no power now. He had power to implicate her and, quote, turn this into something it's not. He did that. He had the power to talk to Hitchens. He had the power to get Hitchens to go talk to Cindy. He had the power to get Cindy to talk to Mary Brinkman. As soon as he got up on that stand, again, unless you are all, as Mr. LaPrinzi says, fools, you realize the powerlessness and the hopelessness. Quite frankly, just the sad nature of Chad Cobb at this point, because he's lost his power. He lost his power the moment that Erica stood up and said, no, I'm not pleading guilty to this stuff like you did, Chad. I'm going to put my trust and my faith in a jury. I'm going to put it all on the line. I'm going to put myself out there. I'm going to put myself on the witness stand, even though I don't have to. And I'm going to lay it all out there. And when she did that, she grabbed the power back from Chad Cobb. You have those jury instructions in front of you. I know you guys are going to read through those. You've got to find beyond, and I'm just going to gloss over this real quick because you can read it for yourselves. You must find beyond a reasonable doubt that Erica did purposely, with prior calculation and design, cause the death of Ashley Biggs. Murder, you must find beyond a reasonable doubt that Erica did purposely cause the death of Ashley Biggs. What's purposely? It's an essential element of the offense, and they have to prove that she acted purposely beyond a reasonable doubt. These are not semantics, and you're not fools. A person acts purposely when it is her, quote, specific intention to cause a certain result, the death of Ashley. They need to prove beyond a reasonable doubt in both the ag murder and the murder. Look, it's the same offense, okay? But because they've got to prove that she acted with purpose, with intent. They need to prove beyond a reasonable doubt that, quote, there was present in the mind of Erica a specific intention to cause her death. They can't do that. Quote, to do an act purposely is to do it intentionally and not accidentally. The same problems the state has with The purposely requirement are the same problems they have with prior calculation and design. There's no evidence for either of them. Now you're going to see in their complicity, and this is where Miss Easter said, hey, you're in for a penny, you're in for a pound. Talked about that in opening statement. And in this instance, in for a penny, in for a pound is into plant drugs, in for a murder. Into plant drugs, way over here, in for a murder, way over here. You're not fools, and you won't be fooled. They need to prove beyond a reasonable doubt, pursuant to the complicity instruction, that she aided and abetted Chad Cobb in the commission of murder and aggravated murder. They cannot do that. She aided and abetted in the commission of planting drugs. They have to prove beyond a reasonable doubt that she shared the same criminal intent as Chad Cobb. Think about his intent. Think about what he did alone in that parking lot without her there. They can see that. She cannot share that intent. She did not share that intent. You heard the stuff about co-defendant testimony. Grave concern, great caution. You've already got a million other reasons to have grave concern and great caution with Chad Cobb. We don't even need to talk about it. They want to say that Erica is now lying to save her behind, right? She's got a vested interest. She'll lie. She'll get up there and she'll say anything to help herself. And if we had the burden of proof in this case, I would tell them they've got a point there. If we had to prove her innocent rather than them having to prove her guilty beyond a reasonable doubt, I'd say, you know what? You got a bit of a point there. But we don't. Again, them saying that is trying to fool you and change what your job is to say, well, is Erica lying or is Chad Cobb lying? And whoever we think is lying more, that's who loses? No. They have the burden. So let's inquire as to whether the government's witnesses, we don't have to put anybody on. We don't have to do anything. They do. So let's talk about their witnesses and whether they have a vested interest in lying to help themselves. Chad Cobb, yeah. Cindy Cobb, that's her baby. Their witnesses are Team Cobb. Their witnesses have a vested interest to lie. Not to mention the fact that their witnesses, who not only have a reason to lie, their stories and their testimonies are completely implausible. Mr. LaPrinzi made a big deal out of her, you're only telling the truth now. This happened in 2012. You had all these opportunities. You had all these years to come forward and give this statement and tell the truth. Talked about it a lot. He did that because there's only one thing to criticize her on her statement about: the timeliness of it. There's just one problem with that. This room right here, in front of this jury, is her real opportunity to be sworn in, be under oath, in front of all of you, in front of the cameras, in front of the world, to tell her truth at her trial. That's when a person is going to get a fair shake. That's when a person is going to have their unalienable right to take the witness stand. She didn't have to do any of that. She didn't have to go through all that discomfort and all that risk and all that nervousness, but she did. She got up there and she told her truth. She didn't say anything before because she had an absolute right not to. She'd incriminate herself in this drug planting plot, and she's following the advice of an attorney. I'm not going to criticize her for that. On that witness stand in front of all of you is the only place in the entire world where she can tell her whole truth and it will be actually considered, because you all have been sitting there considering this evidence. She has faith in you. She doesn't have faith in the police. She has faith in you to look at it from both sides, to look for the logic in it, not Detective Hitchings. He had his mind made up. The state had their mind made up. What were they going to do? Oh, it was about drug planting. I'm sorry, ma'am, this is a whole misunderstanding. Bye-bye aggravated murder and murder? No. She has faith in you. She has faith in this jury's been showing up through endless delays, illness, without a complaint. Showing up here, staying awake, taking notes. She has faith in you. And she has faith that you'll take your job seriously, that you hold them to their burden to rule out logical doubt. Now, there's a lot of testimony here, not about a plan for murder. There's a lot of testimony about Erica being a bad person. She's bad. She's not a good person, therefore she's guilty of murder. If your job was to find beyond a reasonable doubt that in 2012, Erica Stefanko was a bad person, I think the government has a chance on that case. If State of Ohio versus Erica Stefanko is proved beyond a reasonable doubt, Erica was a bad person in 2012, they've got a good argument there. But that's not your job. Look through the jury instructions. Find in there where she's charged with being a bad person. Look in there to see that if she's a bad person, that's relevant to anything. It's not in there. It's an attempt to fool you because they think you're fools. We do not. We know that you're going to look right through that. And I'll admit, there's part of me that thinks that back then, the things that Erica did and said would be an indication that she's not the best person. Since then, several important things have happened. She met Mike Stefanko. He sat on that witness stand and he told his truth. And she went to jail. I've been doing this job a long time. And I've seen clients get humbled and people get humbled in all sorts of ways. I've seen people reform in all sorts of ways. It's really nothing better than jail to do that. And she's been sitting in that jail for years and years and years. And she's changed. So, what's your job? Your job is to see through all of those tricks and attempts to fool you from the state, to take your eye off the ball, to make you forget that you just have one job. Hold them to their burden to rule out logical doubt about this case. You know what those logical doubts are. That the most logical plan here is to plant drugs. And we don't even have to prove that. Remember? What's logic here? That they would go from marijuana to meth, not marijuana to murder. What's logical here? That Chad Cobb, that maniac that they put up on that witness stand that's now denying it, acted alone with his own state of mind, with his own purpose and his own intent that had nothing to do with Erica. Look for evidence of a plan. When you can't find it, a plan for murder, excuse me. And when you can't find it, logical doubt. They haven't ruled it out. You're done. The jury instructions in this case, if followed, they only lead you in one direction. They only leave you with one option, in my opinion. And that's not guilty. A complete acquittal. If you're in for a penny, you're in for a pound. If you're in for planting drugs, you're in for planting drugs. That's all she was ever in for. Now, I really, really appreciate your time today and throughout this case. There is no better group of people, and this is not bluster, this is just a fact. You sat here through all of this. There's no better group of people on earth to decide this case. There's no better group of people on earth to do your one simple job. Hold them to their burden to rule out logical doubt. And we have complete faith and trust that when you execute your one job, there's only one conclusion in this case: not guilty of aggravated murder and murder. Thank you very much.
Thank you, Attorney Laybourne. The state now has an opportunity to respond.
Thank you, Judge. I'm sure you are not thrilled about me standing up here right now and now talking to you some more about this case. I imagine right now you're all just ready to go in the back and do your job. I get it. However, because I can't read your minds, I would be remiss if I didn't at least get up here and try and respond to some of the things that Mr. Laybourne has said. He spoke for an hour. I'm not going to respond to all of them. And just like he said, this is going to be up to you to make the logical arguments for both sides. So I'm going to just hit on some topics. This is rebuttal. It's not a planned closing argument. So I'm going to be a little bit scattered about what my arguments. One of the things I first want to do is apologize, because I know I was the one that was sick and that you guys ended up extending your stay here for an additional week because of me. And I apologize for that. Obviously, that has nothing to do with your deliberations, but I appreciate you guys still being here and being included in this. One of the things I got to say right from the start, you have this, right? This is the law. This is the law. Now, here's the one thing I want to talk about. I understand that the defense spent a lot of time disparaging Detective Hitchings, myself, mocking me, mocking him, mocking us, mocking the state. I get it. That's his job. That's what he's going to do. What I'm here to do is focus you on the facts in this case and the logical arguments. And one of the things that is not in here, which he must have said 100 times, rule out logical doubt. Did you hear the judge use those words? No, you did not. You didn't hear the judge say that one time. It is not in here. So why is he trying to get you to use that standard when it's not the standard in the state of Ohio? Why? It's a play on words. Why not just use the words that the law is, what the judge said? Why did he say it so many times? Maybe he's trying to fool you. Maybe he's trying to distract you from what the actual law is, just like they're just trying to distract you from the facts of this case by disparaging the people involved in it, mocking the people involved. They talked about everybody in this case except for the one. Our star witness isn't Chad Cobb. Our star witness is sitting right there. These are her words. And what's the other thing that he said over and over and over again? He tried to make it like I insulted you by saying you're fools, that we think you're fools. And this is why we're doing all these things and putting Chad up there and wanting you to believe this because you're fools. Think back about the testimony. What was it? What did I say? What was my comment? After spending so much time with Mrs. Stefanko, talking about how she lied and lied and lied, deception. She's trying to set up people and get them convicted for crimes they didn't commit. We talked about how she lied to get out of trouble. And my comment to her was, a jury would have to be a fool to believe you. That was the fool comment. Nothing about what he said, but that's your memory that's going to control there. But if you go back and think about it, that's what the fool comment was. Anybody would have to be a fool to believe her. And why is that? She's a self-admitted liar. She has lied every step of the way in this case. So what is the state's case? They want to act, you can say 2 + 2 is 5. It doesn't make it so. So they can say there's no evidence, there's no evidence, there's no evidence all day long. That doesn't mean it's so. So what are we going to do? We're going to direct you to the evidence. Nobody in this case, the state of Ohio, does not think that Chad Cobb is some hero here. Chad Cobb is despicable. Do you see those pictures of what he did to her? We know that. We're not trying to fight that. We know he killed her. And you know what? He doesn't have to say it for us to believe it, right? We know he did it. We got the evidence to prove it, right? She didn't tell us he did it. He didn't tell us he did it. So why are we all agreeing to it? Why do we all know it? Because we're using our common sense and reason. Just like we talked about at the beginning of this case. We talked about the driver on the side of the road, how we weigh evidence based on our common knowledge, logic, common sense. Use it. We don't want you to contort your brains to match some story that she came up with. So let's look at this case. Let's look at what we did in this case. They want you to think that somehow we're relying on Chad Cobb. So if that's the case, why didn't we in 2017, when Chad Cobb wrote the letter indicating what happened in this case, why didn't we go out? Why didn't the detective go out and arrest him? Because we know Chad Cobb is a horrible person, and then he lies. But just like she lies about things that she thinks helps her and tells the truth about the things that help her. He does the same thing. He's lying about part, he's lying, and he's telling the truth about part, right? Clearly he went there. Clearly he killed her. We put him on because we had to prove a murder took place. I can't just show you a picture of dead Ashley Biggs and go, hey, look, Chad Cobb's murdered her because there she is dead. Somebody had to come in and testify about it, right? And he did. And then he only admitted to a complicity. That doesn't mean he didn't actually kill her. We're here on a theory of complicity with Mrs. Stefanko. So let's look at this. We know that Chad Cobb did this, right? They tell you it makes no sense for murder. And let's talk about murder for a moment. They want you to think that just because murderers did something illogical, that it can't be so. We know people kill every single day in this country for stupid things, for tennis shoes, for $20 in a cash tip. People kill for stupid reasons. They do it on video. That doesn't mean it didn't happen just because it's illogical to do it on a camera or for $20. We all know that nothing is more dangerous than domestic violence situations, right? Custody, divorce. Things get really heated over that type of stuff. And children. And to suggest that maybe murder isn't even logical over a custody dispute, that's just not right. We all know that people kill for much less than to save their children or to keep their children. And let's, maybe because of the context of murder, that murder is so bad, so serious, so finite, that when we talk about her planting evidence, trying to set up something, you think about that just for a moment. I want you to really put yourself in a situation where somebody like your neighbor, if you had a neighbor dispute or somebody you didn't like at work, think about what it would take for you to go get drugs and plant them and call the cops on that person. Can you imagine doing that? And she does it and talks about it like it's no big deal. That's significant. Who does that? If you know one person that's done anything close to that, I'd be shocked. But she did it. Now, she's using that, her own discretions, to try and convince you that that's what she did the second time. However, there's one thing that they don't tell you. Just like we know, she was the reporting party in that case. She gave her name. The first time she set her up. Hey, this is Erica Stefanko. Erica lying. And there's a girl who's driving around with drugs in her car. And she's got kids. Right? So why then, if they're just doing this setup again, do they need all the secrecy? Why do they have to go out and buy phone cards and burner phones? Why do they have to conceal her identity? Because it's not about planting drugs. It's because they had to hide the murder, right? Because an anonymous caller or her calling and say, hey, listen, I have information. She's carrying drugs in her car. There's nothing wrong with that, right? So why hide it? Why go to the lengths that she went to? So we know that Chad Cobb goes there and he kills Ashley. They want you to believe that the plan was to plant meth, and that is why she keeps saying it went awry. I really hope that you see through that for what it is. To suggest that that is so clear that she's talking about a meth deal and the reason it went awry. How does murder go awry? Like, oh my gosh, murder goes awry when you get caught. Would everybody agree, right? Nobody plans to do a murder and get caught. That's the part that goes awry. And they've indicated, where's the plan for murder? You know, go back through any of the evidence, any of the testimony, no matter what it is. There's no discussion, no talk about meth being planted, ever. Ever. What they do talk about is Ashley's death. And they talk about that in the context of the plan. That's what they're talking about. They're not talking about Ashley getting caught with drugs in her car. They're talking about her death. So we know that there's this death. And by the way, he says, well, what would their plan be? Just because they may have had alternate plans, right? You can have hey, this is what's going to happen, but if this happens, then we'll have to do this. But the fact is look at this. Now, I almost thought he was going to actually go to the lengths of saying, if it all fits, you must acquit. That has nothing to do with this. The size of this bag, what goes in or doesn't go in, it doesn't matter. And it's really interesting because he used the example, I'm getting a little side here. He used the robbery where somebody gets out of the car, they got the guns, and they go inside. Yeah, of course that person's guilty because they saw him get out of it. Let's just talk about the logic of that for a moment. That's exactly the reason why she had to say that he got out of the car wearing a t-shirt and jeans. Because if he got out of the car looking like this picture, where it went, looking like that picture, clearly she would have known that he was about to go kill him. Clearly that it wasn't for planting a drug. They remember it. And that's why they had to change that. So what does that mean logically? Talking about logic. So the plan was to now all of a sudden go buy cards, phone minute cards, go buy burner phones, and do this whole elaborate plan for her to drive him there when she could have made the call from anywhere. And not only that, he's going to take everything in this backpack, get out of the car, and change. Really? That would kind of be like in the robbery situation, where if the robber got out of the car with his backpack, went into the bank, went in the bathroom, changed his clothes, and then did the robbery. That's what they want you to believe. They want you to believe illogical stuff in order to match her story. Now remember, she's confined by her story by the facts in this case, by that tape recording she had, or that she's on. What she's had for years. She's had that for years. And she's had the opportunity now for 5 years, or whatever it's been, since she's had it, or known about that tape, to come up with this version of events. So we know that they go there, we know that she's dead, and we know that she has a conversation about it with Cindy Cobb. Take her version out of it. Take her statement out of it. Common sense and reason. You've got a phone call that she is admitting on tape that she did. You've got a murder. You have got Chad Cobb and all the evidence that points to Chad Cobb actually doing the murder. You got her driving there. You got her hiding behind the barn. You got her driving to the field and picking him up after he dumps the body in the field. She is completely involved in that evening. There's no question about that. She doesn't deny that. So now you hear this tape, and all she talks about is the plan. So we know there's a plan. And that's why in our discussions is it comes down to what you believe. If you believe that plan was to kill Ashley, it is unequivocal. Premeditated, prior calculation designed murder. And she's complicit in that. We all know that. So the only thing that takes us away from that is her story, which nobody's heard before. She's had years to come up with it. And the only time anybody talked about meth or planting of these drugs that night is her. She is the only one. Think about it. Nowhere in any part of this case, nobody, no person, not Mary Brinkman, not Cindy Cobb, not Chad Cobb, not one person ever talked about that. No person, there's no evidence of that. The only person is her. So the question is, do you believe her? And that's where we come back to being fools. It kind of feels like a little bit like, I don't know, Charlie Brown. How many times is he going to let Lucy put that football down and he try and kick it, and then she tries to convince him, go ahead, go. I won't pull it this time. How many lies does she have to tell? Right? She's told so many lies throughout this process. What's it going to hurt to tell some more? And now, all of a sudden, she wants you to believe her. And that's her problem. The problem is if you just look at this as a whole, what happened that night, her conversation with Cindy, it clearly matches up that her and Cindy are talking about the murder of Ashley. They're not talking about planting drugs. So she has a problem because she's not credible. She has a problem because she lies. She's been caught in lies. She lied to the police multiple times. She tells us she lies to keep her kids. She told us on the stand she lied to stay out of trouble. And now she's in a lot of trouble. And so what lengths does she go to try and buy credibility, right? She needs to buy credibility. She needs to convince you one more time to take a kick at that football. That's what she needs. And what does she do? Well, she admits to felonies, even though she can't be prosecuted for them. So no loss there. She admits that she's a liar because she's caught in lies. We know that. There's police reports of her reporting drugs in somebody's car. She admits to lying to the police. She admits to setting up innocent people to be convicted of crimes. She admits to lying to cover her Chad. She even goes on the stand and is trying to tell you and suggest, and she did it with Cindy too, a ploy for sympathy, is that if she goes to prison, she may even kill herself. Hoping maybe that if she tells you that, makes you think that you're going to go, oh my God, I don't want her to kill herself, so I'll just find her not guilty. And the coup de grace, she admits. She's got her attorney up here telling you, geez, I don't think she was a good person. The coup de grace for all those people that are parents or moms. I was a bad mom. That's the length she's going to go to get you to believe her this time. Now, none of that matters because whether she admits to being a bad mom or not doesn't change it. It doesn't hurt her if she's found not guilty. She doesn't care. She doesn't care. But that's her trying to get you to kick that football one more time. And if you recall, it was Mr. Laybourne that asked her all the questions about you were a bad. That doesn't seem like something a good mom would do. That doesn't seem like something a good person would do. I never asked her one question about being a good person or a bad person or a good mother or a bad mother. The only questions I asked her about was being a liar. And she admitted that because she had to. Like I told you in voir dire, we are not here to prove whether she's a good person or a bad person. I'm not here for that purpose. I'm here for one reason, and that is to determine whether we can firmly convince you that her and Chad Cobb planned on the death of Ashley Bates. And that's it. It's formulaic. Think about the information they put out there. What does Mike Stefanko's, hey, listen, I feel bad for that guy. He's gone through a lot. He's had 2 siblings die, one at a very young age, one of an overdose. He's had a bad situation. I get it. Why did we hear about it? Why did we hear about them being soulmates? Why did we see pictures of the kids with Mike? Why did we hear about how hard it is to raise all these kids and try and keep the financially everybody afloat? Why? What does that have to do whether she conspired or was complicit with Chad? It's a ploy for your sympathy to feel bad, like, oh my gosh, well, you know what? I think, you know, I'm convinced she did it. I'm convinced she made the call. I'm convinced she brought Ashley there to be killed. But she only made a phone call, so maybe this is too much. Maybe it's overkill to find her guilty of being complicit in a murder. And you know what? She's got kids and he needs help. And you know what? She might kill herself. That's what that's all about. They're trying to do what? The one thing you can't do, and that is use sympathy to make a decision, whether it be for Ashley's side or her side. But that's what that's all about. That's why it's here. There's no other reason. There's no relevance to any of that. So why are they doing it? It's a distraction from what? Her own words on that tape, admitting to knowing that Chad was going to keep a trophy, the skull. Now, that may have been an exaggeration, but that isn't about meth. The other thing that they keep talking about is how she's been in jail. And nothing about that has anything to do with this case. Nothing about how long she's been in jail should be any part of your deliberations. Whether she should have been or shouldn't have been in jail this time does not matter. That's not what we're here for. But again, sympathy. Oh, well, she's already spent 4 years in jail, so that's good enough. That is not why you were here. That's for the judge to decide. So sentencing and sympathy, 2 of the things that they seem to be throwing in your faces over and over and over again, are not to enter into your deliberations. one of the other things, and they talk about the going awry. One of the other things we don't want you to get confused about is if I go there to kill you and I was going to stab you and you ended up, I saw you had a gun and I ended up shooting you, just because my plan was to stab you and I ended up shooting you, doesn't mean it wasn't premeditated. It's not the method in which you die. It's the purpose that you go there for. So whether he strangled her and was going to stab her or vice versa, it doesn't matter. So when you hear that the plan went awry, that the fact is it doesn't change the manner that she was killed, okay? And that's just a simple point. I want to make sure that's clear. They did talk a little bit about the perfect plan. So we know that Chad was really upset, and we all know that Ashley kind of disappeared for a little while. There was a couple years there she was gone, and she never came back, right? So keeping that in mind, and I'm just kidding. They just said, what would the plan be? I'm going to just throw this out there. I don't have to prove this. But in looking at what he had, looking at the history, they were doing all kinds of stuff to try and make Ashley look like a bad mother. And so they go to the extent to try and plant the drugs. That doesn't work. It didn't work. The police didn't buy it. Well, what if we do kill her? If we get away with it, we clearly get Grace back, right? I mean, that makes sense. Now, you and I wouldn't do that, but clearly they did it. We know at least Chad did, right? And you're here to decide whether she was involved in that. So what's the perfect plan? Well, we want to get her somewhere quiet, somewhere dark, somewhere secretive. You saw that place. At nighttime, it's dark. There's no lights. There's a light there, but it's not on. We don't want to shoot her. That makes noise. We don't want blood because that leaves evidence. So if we go there, we tase her, incapacitate her, tape her mouth shut, strangle her. There's no blood. There's no noise. We can take her and get you. Who knows what the plan was originally? I don't know that they initially wanted her to go to the field or not. They could have taken her 100 miles away. And for a long time, people might have thought, hey, she just took off. Nobody would know. And quite frankly, the fact is but for Ashley spilling blood that night, because probably it seems like what happened was when he tased her, it didn't work. He must not have made a good connection. Maybe because the clothes were there or whatever. But you can see there's only one, there's 2 marks on her back, but only 1 stuck in. So when he tases her, it doesn't work. That's where it went awry. And she fought back. And you heard she was a stout girl. She fought back and blood was spilled. Now that whole plan of just getting rid of her without leaving any evidence in that location changes things. And now everything goes awry. Because why? Now there's potentially blood on him, right? If not, he could have gone, I mean, and think about it. Even with all that, the only evidence that we had linking him physically to that was some blood on his sock. Now, there's other blood on his clothing. It wasn't tested, but there was blood on his sock. But think about it. If it wasn't for the blood on his clothing, there would be no DNA. There would be no DNA. He could have gotten away with this. If she had been tased, incapacitated, he could have put her in that car, dumped her anywhere, and we would never, well, we would suspected him, but what would have been the evidence? There wouldn't have been. That would be a perfect plan. But it went awry because he didn't tase her correctly. He didn't get it done. And that's just one theory. You could probably think of 1,000. But for them to say it's not logical or that it went awry, how could it go awry? She's dead. It's going awry because he got caught. Ladies and gentlemen, I think I've been talking enough, and I always thought when I was in law school that the goal was I was going to get up and I was going to convince everybody of my point of view. I actually hope that I didn't. I hope you already are convinced that after hearing closing arguments and the tape that you are already clearly in the position of she's a liar and we can't believe anything she says, and therefore when she says about the meth, I have to completely ignore that because we know she lies to get out of trouble. And what more trouble can you get out of than this, right? The jury instructions say for reasonable doubt. And remember, reasonable doubt, that's the same standard for a traffic ticket, right? I mean, it's the highest, but the same proof that I would have to prove that you were speeding is the same level of proof we have to prove here. It says proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely on and act upon it in the most important of their affair. Would you rely the character of the evidence? So like we said, the only evidence in this case that the plan was to plant meth came from her. Is she the person you would rely on in the most important of your affairs? If you were going to buy a house and she was the real estate agent, knowing what you do know about her, and you said, you know what, I can't have a flooding basement or termites. Is there flood or termites in this house? And she said, oh no. Would you believe her, knowing that she lies to the police, plants evidence on other people? Would you rely on her statement and buy that house? Of course not. And that's what we're asking you to do in this case. We're asking you to not give her any credibility. And without that credibility, there is nothing but a tape recording of her talking about a plan, talking about skulls, and talking about the death of Ashley Biggs. That makes her complicit beyond a reasonable doubt. That should firmly convince you. And if there's one last thing to tell you, that she is not talking about planting meth. When she talks about that, when she talks about going to prison, she doesn't talk about going to prison for possessing meth, low-level felonies. If you maximum consecutive sentence for what she admitted to on the crime she committed, it'd be hardly nothing. But what is she talking about on the tape? 15 years. That's more in line with a murder sentence, isn't it? Because that's what they're talking about. They're talking about murder. They're not talking about meth. If she was caught with possession of meth, she'd probably get probation. But she's talking about 15 years of prison. That's significant. They just glossed over that. The fact that they're talking about so much time, and that's because she would be going to prison not for the meth, but for murder.
Your Honor, we object. He's burden shifting, and he's talking about punishment, which is the purview of the court.
I'm talking about her statement where she talks about 15 years.
He's talking about punishment.
So the
We object.
okay. Just to instruct the jury, sentencing is up to the judge.
And when she was talking to Cindy Cobb, she was talking about a murder type sentence, not a possession or tampering with evidence type sentence. And that's how we know that the conversation he was talking about was not about meth. So with all those things, with her credibility being zero, with the conversation as it is between her and Cindy Cobb, talking about the plan, talking about keeping skulls, there should be no question that she is complicit with Chad Cobb in committing the murder, premeditated, prior calculation design murder.
At this time, I will now instruct you on how to conduct your deliberations and prepare your verdicts. This is on your paperwork on page 11 if you want to follow along. It is your duty to carefully weigh the evidence, to decide the disputed questions of fact, to apply the instructions of the law to your findings, and to render your verdict accordingly. Your duty as jurors is to arrive at a just verdict. Consider all of the evidence and make your finding with intelligence and impartiality and without bias, sympathy, or prejudice so that the state of Ohio and the defendant will feel that their case was fairly and impartially tried. If during the course of the trial, you have an impression that the court has indicated how any disputed fact should be decided, you must put aside such an impression because that decision must be made by you based solely upon the facts presented to you in this courtroom. Your initial conduct upon commencing deliberations is important. It is not wise to express immediately a determination or to insist upon a certain verdict. Having so expressed yourself, your sense of pride may be aroused and you may hesitate to give up your position even if it is shown that it is not correct. Consult with one another in the jury room and deliberate with a view to reaching an agreement if you can do so without disturbing your individual judgment. Each of you must decide this case for yourself. You should do so, however, only after a discussion of the case with the other jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should not surrender your considered opinions in order to be congenial or to reach a verdict solely because of the opinion of other jurors. To begin deliberations, you must first select a foreperson. The person you select to preside over your deliberations as the foreperson does not have any greater power, nor does that person's vote have any more importance than others. The foreperson serves the purpose of helping to conduct your deliberations in an orderly manner and to give each of you the opportunity to express your opinion. One additional duty of the foreperson is to see to it that the verdict form and any exhibits are returned to the court after you have reached a verdict. It may be difficult to remember all the instructions that I have given you. If during your deliberations you cannot remember or are in doubt about a portion of the instructions, or if you have a question, it should be discussed in the privacy of the jury room. Then you may reduce your question to writing so that there will be no misunderstanding as to what is requested. The foreperson will put the question in writing, indicating specifically what is requested, and deliver that communication to the bailiff. The writing you provide to my bailiff should not reflect the status of your deliberations. Verdict forms. I will now read you the verdict forms. Verdict form 1, count 1, aggravated murder. We, the jury, being duly impaneled and sworn, find the defendant Erica Stefanko. Then there is a blank, and in that blank with ink, you will either insert guilty or not guilty of the offense of aggravated murder as charged in the indictment occurring on or about June 20, 2012 through June 21, 2012. After you come up with your verdict there, you each need to sign the form in ink, and then you'll go to verdict form 2, which is count 2, murder. We, the jury, being duly impaneled and sworn, find the defendant Erica Stefanko. Again, you'll insert here in ink either guilty or not guilty of the offense of murder in the commission of an offense as charged in the indictment occurring on or about June 20, 2012 through June 21, 2012. Again, each of you will need to sign this form in ink. In order to conclude this case, it is necessary that all 12 members of the jury agree upon the verdict. Whenever all 12 members agree upon the verdict, you will sign the verdict form in ink and advise the bailiff that you have reached a verdict. When you have reached and signed a verdict, you will summon the bailiff who will return you to the courtroom, at which time your verdict will be announced. You are warned not to discuss the status of your deliberations with anyone outside of the jury room, nor are you to discuss your verdict with anyone other than your fellow jurors until it has been returned to the court. Exhibits. The court will place in your possession the exhibits and the verdict forms. The foreperson will retain possession of these records, including the verdict forms, and return them to the courtroom. Until your verdict is announced in open court, you are not to disclose to anyone else the status of your deliberations or the nature of your verdict. There are a couple exhibits that will not be going back with you. If you do need to see those, please let my bailiff know, and someone from the court will bring them. Conclusion. You will now retire. First, select a foreperson, and whenever all of you agree upon the verdict, that foreperson will complete and sign the verdict in ink and advise the bailiff. You will then be returned to the courtroom. For alternates, a juror selected as an alternate is not permitted to participate in the jury's deliberations unless one of the other jurors is unable to complete his or her service due to illness or other misfortune. We have had to use one of our alternates, but we are pleased that no other alternates have had to be used. So it will not be necessary for the three of you right here to render further service in this case. The alternate jurors continue to be part of the jury panel while the jury is deliberating until the jury has reached a verdict. The alternate jurors cannot discuss the case with anyone or disclose to anyone how they would have voted. After the jury has returned its verdict and the verdict is announced in open court, the alternate jurors will be contacted and released from all restrictions. And at that time, you may, if you wish, discuss the case. I believe Adam has all of the alternate jurors' phone numbers. Is that correct? Okay, and if you want him to call you when the case is completed, you can request that when I release you. So for the jury, and again, thank you very much to our alternates. Your service is greatly appreciated. Your attention and your timeliness every day is also appreciated. You are now on your own schedule. We're required to keep track of the time you spend deliberating. So lunch is back there. You can go back, elect your foreperson, and again, that foreperson will be responsible for notifying the court. Adam will show you there's a button if you want to take a break while deliberating. Okay, thank you, everyone.